And let's get the timer set. All right, so first I want to start out by thanking everybody for joining us on this Saturday and coming to our NOLO class. We wanted to give an overview on NOLO Trust. They have a couple different packages. We're going to be going over today the NOLO Trust book. They do have a new version out, the 15th edition, so I recommend getting that. But also, they have a fillable software, the Willmaker and Trust 2021, and that's what you got the 50% off code for. And that's more like an actual program where you're entering in the data, a little bit more like For Trust and those type of programs. We're not going to be covering that today. We're going to do just the NOLO Trust book that comes with forms ready to use, and go over all of that. So Living Trust Explained, you know, for those of us who are just starting out and adding trust into your business, or interested in doing estate planning and trust for people, a good way to kind of explain that to people, I've heard it a couple different ways. One being a truck, like a moving truck, and just imagine the word trust on the outside of the truck. And as you purchase the truck and form all the documents, then you have to put your property inside the trust. That's called funding the trust. Another way to explain it to people is you're kind of making your own personal corporation. People seem to understand that when you say, you know, you'll be the CEO of your trust, and which is the same word as trustee. So one thing to remember is that each trust is unique. Everybody's going to have their own special circumstances. And so a lot of things that we're going to cover today, there's still many more things that could happen. Some of the benefits of having a living trust and why people would want, of course, is to avoid probate. We're going to go over that in a little bit more detail in just a few minutes and why we want to avoid probate, but that is the main reason for making a living trust. Also, in a living trust, you can manage a minor's inheritance. You can create children's trust, and you don't have to go through a guardianship of the estate and involve that in the public courts and the expense of creating a guardianship. There's no trust record keeping that needs to be kept while the grantors and the original trustees are alive. So it's very easy for them. It isn't until they're passing, until the trust becomes irrevocable, that you need to keep some type of good record keeping going. I want to talk a little bit about the differences in trust. There is a revocable versus irrevocable. Now, we do revocable living trusts where the grantors can revoke it at any time. The surviving spouse can revoke the trust if necessary. I do not recommend that you do irrevocable trust unless you are very seasoned. Otherwise, you want them to seek attorney advice on that before doing that. Once you create an irrevocable trust, the grantor no longer has access to make any changes in almost all cases. And also, you're usually appointing a different trustee, so immediately you're giving power over all of your property and your finances to another person. So before doing an irrevocable trust, you definitely need to make sure that they consult with an attorney, or just send them to an attorney altogether. Same goes with special needs. There are special needs trusts, and same circumstance where they can lose a lot of benefits, and that's usually, special needs trusts are usually for people who have, they're receiving benefits from the state or the federal government, and in order to preserve those benefits, they can only have so many assets. So their assets are rolled into a special needs trust. Those funds can only be dispersed for certain reasons, and there's specific language in there to make sure that it's not conflicting with the benefits they're getting. You know, those can change over time. It's just a lot of liability for an LDA to take on. Again, that's something that you should hand over to an estate planning attorney. I recommend that you find an estate planning attorney to talk to or to work with. I do. You may want to, you know, throw in free notaries for them, for their trust. Anything you can to have an attorney to throw things back and forth with is really, really great, especially with estate planning, because situations are so unique that you'll find once in a while you just need someone to go back and forth with and find out if this is the right fit for you, or should you be transferring that client on to an attorney. Also wanted to talk a little bit about naming your trust. You can name a trust they can name the trust anything they want to, basically. Now, most common and thing that I usually do is the Smith Family Living Trust. You're going to see that in our materials today. That's the most, something along that lines of family trust, but honestly, a lot of times people use the names like Susan P. Smith and John P. Smith Living Trust, any of those things. I've seen them named, the Family Trust 2021, they use the year in there. So the naming of the trust could be whatever you like, but keep it as simple as possible. Because they're going to have to write that out over and over again in their lifetime. So you don't want some big drawn out long name unless it's absolutely necessary. So let's get into probate and why that should be avoided and the whole purpose behind a living trust. As we all know, the fees are extraordinarily high in probating an estate. And NOLO actually had a really good little story about that I kind of wanted to share. Marilyn Monroe's estate, she died in 1962, and when she died, her estate was insolvent. She had quite a few bills. However, over the years, she received royalties, ended up getting like 1.6 million put into the trust. So they were able to pay off all the debts and left just over $100,000 for the heirs. But just so you know, the probate fees and lawyers' fees cost over $1 million for that entire time. So that is why you want to avoid probate. It's mainly about avoiding the high cost. Even if we do it as an LDA, the costs are extremely high, lots of filing fees. And so again, the cost to set up a trust is much, much less expensive than having to go through a probate process. So another part of why probate should be avoided is just the privacy. You have to publish that the estate's being probated in the paper. People get contacted from real estate agents and estate sale people just constantly when these heirs and they're trying to grieve and figure out what to do, and they're just being hounded over and over again by people, and so. That's never fun. So keeping a living trust, everything is kept private. You don't have to publish anything. You don't have to make any notifications to the public in general. You also don't have to get appraisals and find out the cost of all sorts of things, which again includes more fees that have to be done. There's massive amounts of paperwork in a probate, and it's a difficult procedure. It's not very simple, and it's not like family law where everything's really lined out and there's a form for everything. In fact, when you get to the second half of the probate, you have to completely do pleadings and things like that for the distribution. So again, it's a very confusing process, a lot of paperwork, lots of expenses. You have to file at least 2 filing fees in a probate. So money, money, money. Living trust can avoid all of that. I actually give my clients a cost value sheet. I show them the cost of setting up the living trust versus the cost of a probate. And, that's all I ever have to do. If I'm sending out intake forms and things like that, I send that little form showing them the difference, explaining the difference, and they can see the cost value right there in front of them. Some of the other good things about having a trust is that you can most likely avoid out-of-state probate. Because if they have a living trust, you can go ahead and put, if they've got a place in Texas or Arizona or something like that, you can actually change the grant deed and put that into the trust. And that's going to avoid the expense of having to do a probate in another state. Almost all states recognize living trust. You do definitely want to check prior and make sure that that's the case. And all but Louisiana, if anybody has property in Louisiana, consult an attorney first, because their law is completely different than the rest of us. But the other 49 states, you should be just fine on doing a new grant deed for their trust property that's out of state, out of California. Another big benefit is, of course, avoiding conservatorship. especially if you do a complete trust package and you include powers of attorney and medical directives. That's going to help with that as well. But just the documentation in the living trust itself allows for the grantor to be declared incapacitated and for the successor trustee to take over. The conservatorships are just as lengthy and just as expensive as a probate. It is done through the probate court, and you have to report yearly on the assets and keep up accounting. Again, it's a lot of time and energy spent where the trust would avoid all of that. One of what I have found is my probate clients are my best trust clients. So always make sure if you do probate or somebody comes to you for a probate, make sure you're asking them if they have a living trust, because they're ready to purchase and ready to get that going right away after having to go through a probate for their family or their parents or something like that. I definitely recommend reading the NOLO book. They have many chapters that have to do with just what do they call it? Human realities and living trust. So lots of different situations that may come up. And I'm not going to cover all of those today, but I recommend going through and reading their book because they've got just great information. Some of the things they talk about is, leaving unequal amounts to children, what to do in those cases, how to avoid upsetting one of the children, and making sure that all of the children are on board. You, of course, as much as possible, want to avoid a contest. That's the whole point of the trust, is to keep it out of probate court. And if you've got heirs or beneficiaries that have a bad taste in their mouth, they can just blow that out of the water by filing a contest in the court. So some of the things they talk about is talking with the children and explaining why. We gave Johnny $100,000 a long time ago to buy this property, so now the majority of the estate are going to go to the other two children, and Johnny's only going to get this, and just have the grantors sit down and discuss this with their heirs if possible, and that certainly does help. Also, there's some unique circumstances when it comes to second or subsequent marriages. Making sure that sole and separate property, but you're preserving life estates for maybe a new spouse. There's also times when one of the grantor dies, you don't want it to go to the other spouse right away. They want it to go ahead and go to the other, directly to the children, their 50% share. So there's things like that to discuss and talk about with your grantors. And every situation, again, is going to be unique. And hopefully we'll have some time at the end to have some different stories, because it is interesting to listen to the circumstances that we all come up against. Some other things to think about are single persons and unmarried couples. Single persons, of course, can have a trust themselves. Unmarried couples can have a trust together. But again, there might be some specific language in there to clarify things. Disinheriting a child. They have some great suggestions for what to put in as far as wording, a no contest clause. In our sample today, I do have a no contest clause in there, so you'll see that as well. But again, you want to try and avoid upsetting the beneficiaries, because it just throws it back into probate court. So sometimes there's other ways to do things where you're not flat out disinheriting the child, you're not using that language. But they're getting a much smaller amount, or maybe just love. There's other things that you can put in the trust that might make the beneficiary feel better about the situation and help avoid any kind of contest in court later. Some of the common questions are if everybody needs a trust. If somebody owns real property, then they need a trust. Pretty much in every single circumstance, they're going to need a trust. So that's the basis for starting it and thinking it through from there. If somebody just cannot afford the pricing of a trust, there are some other measures. You can certainly, add a person to a grant deed, a child, add them on the grant deed as a joint tenant. However, you get into tax implications there, especially now with Prop 19. I think everything's changed. So before you add on a child onto the grant deed with the parents for joint tenancy, make sure that they're seeking some advice, even at least from a tax person. I mean, legally, we understand what that means, but these days they should at least talk to a tax person and find out if they're going to be subject to more property tax, if it's going to change the property tax. They can talk to the assessor for the county and confirm that as well. But everybody still would need a will package. If they don't qualify for a trust or they don't have enough assets, you can still sell them a will package. I do provide my will packages at a little bit lesser rate for people who can't afford a complete trust package. But in most cases, you want to do the trust package. That allows them to be in full control of their property still, the grantors, as opposed to adding the child onto the grant deed now if they wanted to. If they do that, if they decide to refinance in the future, now both of them have to sign the grant deed, and it just can complicate things more. Whereas if it's in the living trust, the grantors have full control over it until they're passing. Providing for young children. These are some more of the questions as you're preparing the trust and to talk with your grantors about. What age do you want to provide an inheritance? Sometimes 18-year-olds these days should not be given a large sum of money. It won't last very long. So there are ways to keep that still in the trust for them until 21, 25, 35. Goes up from there, right, Nancy?
Good.
And who's going to manage that? Who's going to manage the estate for the minor child or adult child, and control that money and keep an accounting and things like that? So they're really important personal questions that people have to think about. Make sure that they have trust with the people that they're leaving in charge of all these things. And also for personal guardianship, that needs to be lined out and addressed in a will. You can make that mention in the living trust, and there's some back and forth on legality of that, but you'll see in the NOLO, the sample that we have from NOLO, we do put in a guardianship of the person in the will. You want that to be stated in the pour-over will and in the will that you have for them. So some other things to think about, and some other things people may have questions on, are estate taxes, gift taxes, creditors, and many other situations. When to file taxes, what taxes need to be filed. So again, reading through the NOLO books are really, really helpful. They've got a lot of different tips on that, and different ways to answer those questions for people. Let me see if there was any questions in the chat here. 10 minutes. Transfer on death deeds. No. Oh, yes, thank you. Transfer on death deeds, yes, Lisa, that's the same as joint tenancy. I mean, they are different ways of vesting, but they do the same things. But once you put them on there, there's still now a second person on that grant deed. So if the grantor wants full control, a trust is still a better way to go with that. Tyler, yes, I'd be happy to send out that form. I'm assuming you're talking about the costs of the trust versus probate, and I can certainly post that up and send that later. And let's see, I did want to show you guys as well. So I will get to the, on break, I wanted to make sure you guys saw that in your materials, the Word document of the NOLO trust. I wanted to make sure you guys saw that. So you can, when we come back from lunchtime, we're going to start going over the actual trust documents one by one, step by step. And I did include the Word format of the trust from NOLO so that you can type that in as you're going through if you choose to do that. But that's just a sample of one of the documents that you get when you purchase the NOLO book. So, and again, you can purchase the Make Your Own Living Trust, the book itself, and you get those forms downloaded as part of the software, or the Will Maker and Trust 2021, which is more of a, answer the questions, more of a an actual software that you're entering in. Is it the Estate Planning Basic Book? It's Make Your Own Living Trust. Let me see if you guys can see this. How can I? No, it's not coming in there. How's that? I can't see it. No, it's not coming through. Oh, there we go. How's that? Wait, Make Your Own Living Trust. NOLO's got a new version that just came out as well. So, so yes, just want to make sure you guys have those as well. And then we're going to move on to what property to be put in the living trust. So I'm going to hand this over to Nancy so she can answer those questions for you as well. We'll go through that.
Okay. Good morning. You had a quick overview of what NOLO can do with your living trust. Jenny has version 15. I have version 14. And we found there were some discrepant idiosyncrasies between the two versions. So make sure whichever one you use, stick with it. We're going to be talking about property to put into a trust. And one thing I wanted to talk about was CalDA has provided a questionnaire for trust. So people, usually an adult child, will come in and say, Mom or Dad needs something done. You hand them the questionnaire, they take it home. You don't know if you're going to see it now or 5 years from now, but they come back and it's all filled out. So then for my business, I have the people who are making the trust make an appointment and come in and sit down and talk to me. And they come in and say, we have a house, we have a couple of cars, our kids are grown, we don't have that much, we don't even know why we need a trust. So as Jenny suggested, I explain why you need a trust. And then they're going, well, I've heard I can put my kids' names on the house. And I say, absolutely. How many children do you have? And they'll say 5. And I say, okay, who, you're putting all 5 on there? Oh no, we'll just put John on there and he'll take care of it. And I said, that's great. What kind of capital gains will he have when he has to share it with the siblings? And that kind of stops them. And then I say, and what if John doesn't want to? Oh, well, John will always do the right thing. And I went, sure, I'm sure he will. And that's great. So you put John on your grant deed, and then you decide you want to sell the house. John also has to sign off on selling the house, and John decides not to do it. You're stuck. You have no options then. Well, you do, but they're expensive. So then you think about, okay, maybe I don't want to do that. But then one party says, yes, I want John on there. And that's great. My biggest selling point is, so John's on your grant deed, and one of the 3 of you gets in an automobile accident, and your insurance does not cover it. Where are they going to come looking for payment? And they're looking at me like deer in a headlight at that point and say, a trust, we want to do a trust. Where do we sign up? So you need to have some things available in your toolkit to help them see the advantage of doing a living trust. Then you sit back and say, great, you say you have a house, you don't have anything else. Well, a house is great, but do you have any heirlooms? Do you have any things that have been passed down in your family? Well, we have grandma's silver, or we have grandpa's guns, or we have a coin collection. Then they start talking about their personal life. And the reason for all of this is you are now going to hear things that they haven't told other people, let alone their children maybe. And you need to take that into consideration as you're dealing with them, because now you're getting to the heart of why they want to do this trust. They want to make sure their kids can have the option to do what they want when they're both gone. Things that they have not decided between the 2 of them now are coming out. So talking about property to put in your trust comes up. There's a lot more than just a house. So in the NOLO book, in chapter 5, it talks about an overview of the property to put in your trust. Do you want to put your checking account in a trust? A lot of people come in assuming they should, and they can. It's an option. But do you want that on your checks? Do you want people to wonder why your account is in a trust? Are you perhaps not able to handle your own finances? They don't ask you that. They just make assumptions about you and the lifestyle that you have. Do you want to put individual retirement accounts in a trust? Do you want to put automobiles in a trust? These are things that you probably would like to leave out. Automobiles, how often do you change automobiles? Do you want to amend your trust every time you change automobiles? Do you want to, again, like I said, tell the world your checking account is in a trust? And retirement accounts usually have beneficiaries already named that will pass outside of your trust. So those are things that you can suggest they may not want to put there, but again, it's up to them. You can buy and sell property frequently. My thing to them is if you go out and buy a piece of property and you don't get it in your trust, that piece of property could be subject to probate, but not your whole trust. So it makes them aware that they need to stay in touch with you to amend their trust. Life insurance, when you buy a policy, there are beneficiaries named, so you may not want to put that in your trust. One thing you can do, though, is make a list of things like that, like which bank do you bank with? Which life insurance company are you with? And we can add that list, not as part of your trust, but as an addendum or an amendment or attachment to your trust so that your kids can know where to go look. When my dad became ill, he needed something out of the safe deposit box. And he said the key was in the basket. So I got the key and went to the bank and they said, this is not our key. So I ended up having to go to several banks saying, here's the key that I have. Does this go to anything in your bank? I finally found the right place, and he had forgotten to tell me that he had changed safe deposit box banks because they were offering free safe deposit boxes at the time they opened the bank. We think we'll remember all of this, but as we age, we find we don't remember everything. So put it on your list. Make sure your family, your heirs know what to look for and where to look. And as Jenny said, you know, you can talk to your potential heirs and make sure everybody's good with it. But I find more and more folks don't want to tell their kids everything that's going on in their lives. They don't want to tell their children that we're giving our property to whomever. And so again, they die and nobody knows anything. So at least keeping a list of some of the major places that the family is going to have to look for assets is a good thing, and you can just clip it to the back of the trust. Pay on death accounts. If they name a beneficiary without probate, all the funds in the account, when you die, you need to talk about that. Investments. Put down who you're buying your stock from. What company is it? There are so many out there. Community property with rights of survivorship in California works very well. It's very easy to do, except when somebody comes in later and said, oh yes, my spouse died 10 years ago. And I just say, and they think they've done everything. I just ask, what name's on the property tax statement that comes to your house? And they bring that because they think that's the best thing to do. And lo and behold, their spouse's name is still on there. So you need to help them get that part done because really they can't transfer that property to their trust because they don't own all of it yet on paper. So we need to take care of that. An interesting thing I read in NOLO's book, which was helpful, was about digital assets. In this day and age, they include online accounts as well as files that you store in your computer, in online accounts, or in the cloud. Many digital assets, such as email and social media accounts, aren't property that you can leave to beneficiaries through probate. However, you may own digital music, digital photos, domain licenses, and other digital assets that could be passed on. So there is a real learning curve with that as well. Most of my clients aren't too worried about digital items, but their kids sure are. So make sure you talk about that. leaving instructions, leaving passwords to get into your computer. If you each have a computer and you do your own email and your spouse passes away, how do you get in? I have a personal example that my husband became very ill this last summer and I could not get into his computer, and he was worried about getting some bills paid because he paid them online. It was real interesting to have that conversation while someone was ill. And so again, you need to be talking to the partner about all of these things. If it's a single trust, again, another list to put in the back of the trust. You can always update it, change it, whatever, but at least it gives a starting point to the conversation about what to do once you're gone. If you have a client who has employee stock options, then you need to talk to the company about what their procedures are for these things when you pass away. Some of these things you're going to need legal help with this. And it's good to start establishing relationships with attorneys who either specialize in this or someone that will take your calls or your clients or do a consultation. I'm fortunate. I have an attorney that I do all his notary work. So when I need a client to have a consultation, he always tells them how much he charges for the consultation. And then he'll tell me he won't charge them. But the people need to know the value of the information they're getting from the attorney. And so when he says, well, because you're Nancy's client, I won't charge you, they think both of us are the best thing. So again, it's goodwill, it's good PR, they trust you more, they're more open with everything that they want to do. Property you can put into a living trust are usually houses and real estate, small businesses, money market accounts, precious metals, think about that one. Valuable art, collections like stamps or coins, things that that are tangible. If you want to give someone a car, you might want to go to DMV and add their name and make it an or, not an and. I've had a lot of couples come in and the car is in John and Mary Smith. And that's a little more time consuming when you go to DMV if one of you passes away. Co-op apartments. You may not be able to do that. You'll need approval from the co-op board before you can decide to put that apartment in your trust. Mobile homes, the rules on which, when a mobile home can become real estate are very different. Timeshares. Those are different. You need to talk to the companies that have those. Leases, you need to talk to the leasing company if you want to do that. And small business interests, that's probably where many of us are. If you're a sole proprietor, you can do whatever you'd like. But if you're in a partnership, that requires the people who inherit a deceased partner share of the business to sell the share to the other partners if they want it. But that happens after death, so it shouldn't affect your ability to transfer the property through the trust. But maybe you are given that partnership, but the other half of the partnership doesn't want you as a partner. You're going to have some issues there. So these are things your client needs to talk about within the partnership prior to putting this into your trust. Let's see. If you get to subchapter S or professional corporations, I would suggest you get legal advice. A lot of these can be very tricky, and enough said. One fairly common rule is that surviving shareholders or LLC owners have the right to buy the shares of the deceased shareholder or owner. In that case, you can still use the living trust to transfer the shares or the LLC interest, but the people that inherit them may have to sell them to the other shareholders. So again, that's something they think they're getting a great deal and can be part of a company, but they'll be forced to sell it because of the rules that are currently there. Another thing are cash accounts. Do you want to put a stack of cash into your trust? And I thought that was rather interesting because I couldn't picture a shoebox full of cash just sitting there waiting to give to someone. I have people that want to leave certain amounts of money to certain children or grandchildren, and they want $5,000 given to Johnny and $10,000 to so-and-so. And I say, that's great, I'll put that in. Now, can you guarantee me that that 5,000 or that 10,000 is going to be there when you die? And they just, again, look at you with concern. And I said, you know, you do what you want, but NOLO suggests that you might want to open an account and put that money in there, making them the owner, the beneficiary of it, so you do know the money's there. It's not hard to do, but you might want a money market account with their name, and then you're guaranteed the money will be there. But what if you need it down the road? So those are things to think about. Many other types of valuable property can also be placed in your trust, including jewelry, antiques, furs, furniture, precious metals, works of art, and collectibles. From Depression China to antique soldiers to old dolls and stamps. But they don't usually have a title with them, like real estate does. So sometimes you just need to list it and let it go at that. It depends. There are just so many things, but NOLO is written for the layman. NOLO is written to help you think out your life. It is not legalese. And so NOLO really does, for me, make doing a trust very easy, and especially for my clients. Usually it's an adult child that wants dad or mom to get in there and take care of it. And then when it's done, you turn to the adult child and say, and what about you? And again, like Jenny said, referrals are the best things. And if mom and dad are happy and relieved that this is done, the adult child is going to be very happy to have that done and find that you can do that for them as well. California is a community property state. So if it's in joint tenancy, or rights of survivorship, it's going to pass very easily to the spouse. If you have property in other states, you can include that property in your trust, but depending on the state, you may have to do a probate on that property in that state, depending on which one. Again, NOLO breaks that down for everyone. Let's see. In NOLO, you get a property worksheet. It's very detailed, as much as you want. It helps to put things on paper. You may not need all of that information, but it helps them start talking to each other as a couple and deciding what property they want to go into it. They've got a great chapter on how to divide it up. For example, if you're going to leave all your books to your daughter, there's no need to list them individually. But if you have several rare volumes, you may want to list those. It's all in the detail. And then you can't give property you don't own. And I've had people coming in saying, well, I'm in my mother's will or trust, and when she passes, I'm getting XYZ property, and I want that in my trust to go to my children. And I went, you know, that's really great, and I'm glad if you're happy about getting that property, but you don't own it. So you really can't do anything about it at the moment. However, you can make a note of that should this property come to you and you have not amended your trust, this is what you would wish. It will make it a little easier in direction, but again, if it's not in there, it's not going to help you. And you can't put something in your trust you don't own. So on chapter 5 in NOLO, in the volume 14, there's a property worksheet, and it talks about liquid assets, savings accounts, checking accounts, marketable securities, government bonds, stocks, automobiles. I have a client that has restored a couple of classic cars, and the value on those things continues to go up. So he makes sure I know the value is going up. So far, he hasn't changed the beneficiary, but I foresee that coming because he has some people that are more interested in it than he is. And it doesn't matter the value, it's about the asset. But because the value is going up, he's insuring it for more. And there will be a whole different group of folks coming after this heir for this vehicle, should that ever come up. Clothing, generally you don't put your clothing in your trust and list it, but if you had furs or jewels, perhaps, artwork. Here's a big one in my area, besides guns, tools, big tools, little tools. Tools are a big deal. And if you want certain woodworking tools or metalworking tools to go to certain people, don't just say, all my tools go to Johnny. You can be very specific about which tools. And believe me, the heirs will know exactly which tools you're talking about. But if you're clear on that, it should not be an issue with them in the end. How about livestock or pets? You cannot leave your estate to your pet, but you can leave it to a trustee for the pet's care. There was it was years ago, there was a very famous person that left her whole estate to her dog, and they were in court forever. Can you imagine the millions that went into having to be in court on that? Life insurance, usually those proceeds are already set out, so that's going to pass to them. But again, list what company you're with. Promissory notes, I've had some of those where people owe the beneficiaries. That note comes to the estate, and those funds need to go to that estate. Again, the digital assets in this day and age, that's certainly something we need to do. And then list the address of the real estate that you own. I've had several clients buy real estate over the years and just come in and dump them on my desk. I've learned to charge them a little extra, and I set up clear envelopes with each grant deed in it and the address, because yes, it helps to clean it up, but the successor trustee is going to pull their hair out trying to locate all this information and change all the ownership on these things. They think you're wonderful if you can help them sort this out. And then if they go to sell it, the realtor will call you saying, thank you so much for having this in this order because we were able then to facilitate this. What else do you do? And I've had several conversations like that. Business interests. If you're a sole proprietor, it's your business, but who's going to get it when you die? And as LDAs, who's qualified to run your business? Partnerships, limited partnerships, other business interests, your debts. Are there debts nobody knows about? And these are going to pop up after you pass away. Taxes. That's a lot of property and a lot of discussion. But the more you can chat with your customer, the more you can encourage them to tell you what's going on, the better that trust is going to be, the easier it's going to be for the successor trustee, and you will be very happy with the product, because in my community, word of mouth is the big thing. And over the years, one person told another person, and I now have folks with large businesses that could go to any attorney locally, and they come to me because they felt like their friend felt like they had such good service, and they could begin discussions about what to do with this property. So there are just a lot of opportunities using NOLO that will help you and your client feel better about the end product. Okay. Yes, we're going to take some questions.
Let's see what's in the chat here.
Give us a second to look at what's going on. You guys have all been busy out there.
Okay, so autos are funded through the personal property declaration, then it is in. Colleen mentioned that.
I don't understand.
Autos are funded through the personal property declaration. Okay. I don't exactly understand, Colleen, but we'll, in California, I mean, I do understand in California, automobiles are transferred outside of probate.
Correct.
So that's one of the reasons for not changing title and actually putting it in the name of the trust. For one, it's going to throw off DMV, it's going to throw off your insurance because they don't want to give a policy to a trust because they don't know who's driving it. So. And one of the things I'll show you in my miscellaneous forms is in their trust package, I actually provide them the step-by-step instructions of how to transfer the vehicle and a copy of the Reg 5 form from DMV for the beneficiaries. So that is in there. What about using the trust as a contingent beneficiary to life insurance, IRAs, etc.? Answer that for Lori.
As a contingent? I certainly think you just need to do a trust. For clarification, it's great if you only have one beneficiary or maybe two and they just get along so well. But every couple that comes in tells me their children get along, everybody will agree, everything's just peachy. And inevitably, and I bring out my black hat when that happens. I just say that's all great and I'm sure you're right. But what happens if? And the bottom line is they know their children and they know which child's going to be the one that's going to throw a ringer in this. So again, it helps you to be very clear about what you want done, how you want it done. And yes, life insurance and what was the other one? The life insurance and IRAs. Those have beneficiaries already. So basically you're dealing with your real property, your checking account, your current situation, your final arrangements, and how you feel about people. And I'll talk about that in a little while.
And also, she may be asking, putting the trust as a beneficiary, as a contingent beneficiary on that property. So it can be done.
Yes.
And if you have multiple, or they have a contingent beneficiary form, yes, you can do that. But in most cases, you're just going to list the beneficiaries. It's actually easier. The companies have gotten, it used to be that if you had more than 2 kids, they didn't give you the space to actually put it, but now they do. They list multiple beneficiaries. Right. So it's just an easier transfer for people, but if the only option was to put the trust as the beneficiary, then I would say do it, because at least it would go into the trust fund. You'd have a bank account set up in the name of the trust at that point, and that property could transfer directly into the bank account, and you can do what you will with it.
But you need to have those conversations with your insurance company and everything because they've got their own rules.
Yeah, definitely. Loretta is asking if checking accounts are not in the trust, how do the children get money from the bank when they pass?
Okay, for me, one of my suggestions is either put one of your kids on your checking account at some point. Their name does not have to show up on the checks. Their name doesn't show up on the statements that they still probably get. It makes access very comfortable. If in our package, I also put in powers of attorney. So while they're alive, the power of attorney will come into play. If they're named the successor trustee, then that's what comes into play. But again, putting someone else's name on there with yours, someone you trust, can certainly make it easier in the first few weeks to access those funds.
You can also put a beneficiary on the bank accounts as well. But like Nancy said, you may have to wait for the death certificate to come out to be able to claim that. So if you need immediate funds for any reason, it's better to add someone onto it, as Nancy suggested. So Colleen was clarifying for us the list of the autos in the declaration to be clear that they are trust property, then add your trust as an additional insured on your insurance. and no one will ever see the trust name, but it will be defended if you are in an accident and the trust is named to defend. So that's the advanced version, Colleen.
Wow.
And yes, that is great. I mean, that is, if somebody's absolute on it, that is, you would want to follow Colleen's instructions. So that is for someone who's more advanced and feels comfortable with that. And I would give Colleen's number out if you have questions on that, because she sounds like an expert on it. So thank you, Colleen.
Yeah, you know, it's a great idea, but again, getting the legal advice and having your client get that advice so they make that choice themselves with clear minds is an excellent suggestion. And like you said, it's probably more than NOLO would delve into.
What about the grantor leaving a beneficiary a certain percentage, not to exceed 5,000, et cetera, instead of leaving the money in a money market account? Yes, Lori, you know, that's one of the beauties of the trust is you can add as much wording and clarification to any type of situation as necessary. So putting not to exceeds on things, or, you know, if the funds allow, any type of thing. And of course, percentages. In fact, percentages is very, very common. Most people leave things in a percentage for people.
Yes.
So.
And I would suggest that if you've got money in the stock market and you've noticed lately how well the stock market is doing, saying 5,000 could be a drop in the bucket compared to what it will be when you pass away. So again, percentages have a lot more advantages.
Yes, definitely. Peter's asking what the maximum value of an estate that can avoid probate. What's that, at 155 now?
$166,250.
Thank you.
And so you work with your probate referee. Now, some people don't do this, but I have learned over the years to do it. As soon as someone passes away, I send it to the local probate referee. I find out what the value is at the time of the death, and that tells me what kind of estate it's going to be, which saves a lot of wear and tear on both sides. But that is the maximum. And make sure you get the checking account amount when they pass away, because that also is added into that 166,000.
Just looking through the questions here, bear with us. What if all beneficiaries' named die before distribution? We are going to cover that a little bit when we get to the section on beneficiaries, because yes, it's important to have some backups, and we'll talk about the case though if everybody was to pass. But we will get into that a little bit more, Lori. Laverna encountered an interest in the person informed her children of distribution were not equal. Several children are no longer speaking to her. And actually, I'm going to talk about that a little bit when we talk about record keeping. And yes, so you have to, every situation is unique. And Nancy did mention that a lot of people don't want to tell their children and their beneficiaries what they're leaving for them. And it's just for reasons like that. But then again, you know, maybe it's better to find out ahead of time that somebody's going to have a problem with it. So either this can be resolved or time heals all wounds kind of thing. So whatever's necessary to not get into a contest later down the line. But
there is a sample in NOLO about this very issue. And I have my clients write letters sometimes, and we're going to talk about that some more. While mom and dad are still alive, this is what they're saying, and we'll go into the letters because it's very helpful. People being people, you can't predict everything they're going to do. So how did that person find out what your clients were going to do in the first place?
Right.
So
also, they're asking if you put a person's name on your checking account and if they have an accident or are being sued, would it place your money in jeopardy?
Good.
I would assume so. Anything that's considered an asset. Also, if the child filed bankruptcy and they've got their name on their parents' bank account, that can come up as well. So, so there are some instances when that's maybe not the best thing. Every situation is unique, and you know, there's life insurance policies out there for immediate burial expenses and things like that. most burial places are going to allow you to collect any kind of funds or wait till you get that bank account. So sometimes you just do have to wait for the death certificate to be able to go in there. You know, being named a beneficiary on an account does not give you ownership. So that would avoid any kind of liability problems. But that's up to the grantors to keep up on those things and be aware of what's happening in their family. If they have a child that's getting into constant trouble, I would not suggest they put them on any account. So what's the difference between using a grant deed versus a quitclaim deed? A grant deed is a better chain of title. Quitclaim is basically just giving anything you might have. There's no warranty. There's no promise of how much of what's being transferred, or even if they have ownership, they don't even know if they have ownership in the property. They're just quitclaiming, giving whatever they have. That can cause issues. It usually doesn't. I mean, it usually doesn't. If you've done a quitclaim deed before for a trust deed, fine. But a grant deed has more power legally. If you go into the legal verbiage and, dive into the law behind it, a grant deed is a better chain of title for title companies to provide title insurance. And they've even had people come back who've done quitclaims in the past and have them re-sign it as a grant deed because they weren't able to insure it for whatever reason. So when possible, I would use grant deeds versus quitclaims. And I do that for all my things. I do interspousal deeds. I don't use quitclaims unless the customer specifically is like, no, I want to quitclaim, because obviously we're not attorneys. If the customer is demanding that, you give them what they want. So
good.
Parents, some people are saying, yes, parents should talk to beneficiaries, but their children. Don't be like Joan Crawford. That's funny. What if a piece of real estate is left to 10 siblings and some want to leave their children and others want to sell the property?
I don't want to be at that family meeting.
Yeah, I don't either. So if it was to be contested and go to court, the only way the court can settle anything is to demand that it's sold. So that's what would end up happening.
The other thing with 10 children is that some can offer to buy out the others, so you have to have it appraised. You find out the value, you find out the 1/10 value, you can do that. You've got to work it out, basically. The other thing is, and we'll talk about that a little more, is you're leaving that property to your 10 children in equal shares. What happens if one of them dies? Do you want it to go back into the pot for the remaining 9? Or do you want that share to go to that deceased child's children? That's a discussion to have. And so you need to be real clear when you're writing that in the grant deed, how that's going to pass if something should happen to one of your beneficiaries.
Roger's asking if you have to record at the county or probate court. We're going to talk a little bit about that further with record keeping, Roger. Trust in California do not have to be recorded. So we'll get into that a little bit further down the line. And Dalen, yes, we're going to go to the questions and answers right now. So let's take a look at that. We've got about 15 minutes before our break, or we'll break at any time as we get through these.
Bearing in mind that this was the overview. Us.
Yes. Leticia, would their interest go straight to the deceased spouse or deceased children if not specifically noted on the docs?
What?
Would their interest go straight to the deceased spouse or deceased children? Are you referring to the grant deed? Would their interest go straight to the deceased spouse?
Could you clarify?
Oh, okay.
Okay.
Depending on how it's vested. If you're joint tenants or transfer on death, it's going to go directly to the spouse or the children. If it's if you've got it as community property, then that's where Nancy was speaking. Then their share needs to be cleared. If they pass, is their share going back to the remaining beneficiaries? Is it going to their heirs? But yeah, so it's very important about how that grant deed is vested, and then how I would be very redundant. Well, that's second down the line. It's going to be vested in the trust at first. So you need to make sure that the language in the trust is very specific. And again, we're going to talk about that further when we get to beneficiaries, and also in the sample of the trust, we show some different things as well. So So we're going to look at the question and answers. NOLA has various state. NOLA has various state. Oh, I held that up, Patsy, so you saw that one. I understand classic automobiles are usually in the trust, but daily driver type autos are included in the pour over will. Dalen is asking for our thoughts on that.
Personally, I just don't add automobiles to the will or the trust, simply because how often do you buy a new vehicle? Do you want to amend your trust or have a codicil to your will if you change vehicles? But classics are a whole different thing, and that should be going into your trust. If it's specific, put it in your will. Make sure you've covered it and you've got title information. Tell the intended beneficiary where to find title to this vehicle, because they're going to need that.
401ks usually have beneficiaries, so is it best to list the trust as the beneficiary? We kind of covered that. If you can list direct beneficiaries, that's always better and a faster and easier transfer. However, the trust can be used as a beneficiary if they're just not clear on what they want to do or they want to make changes and that type of thing. So Dalen's also asking if we recommend any trust software. I recommend the NOLO. It's pretty much what I use. I do have 4Trust downloaded. I have not even cracked that open yet. Quite frankly, I'm too busy, and it's not as user friendly as I would like to see it. So,
but we may be doing a class on 4Trust down the road, and that's definitely for advanced. We're talking about mom and pop, small estates, not small estates, but limited amounts of property, etc. It's just user friendly. And again, we're not giving you legal advice. So we need to be able to be secure in knowing that what we're sharing with them is coming from approved recommendations.
A few states offer ladybird deeds. If a client has a ladybird deed, it can't be included in a trust because the real estate already has a beneficiary. I have not heard that term.
I have never heard that. That's interesting.
Dalen, so you need to teach us something new. I have not ever heard of a ladybird deed.
Whoops, we have a small alarm going off.
That doesn't want to stop. Okay. We're good there.
Good. The other thing, back to the grant deeds, you're putting your trust into you're putting your property into your trust. When one partner passes away, we're going to talk about what to do when that happens. But again, you need to remember that no matter what, if you don't own it, you can't put it in your trust. So taking care of cleaning up, tidying up these things at the end is as important as doing the trust. And we will be highlighting that.
What do the successor trustees, beneficiaries need to do when the trust passes to take charge? Do they take the whole trust document to all office of the relevant authorities? We are actually going to answer that right when we come back from break. We'll be diving into initial and successor trustees and changing trustees and what documentation is necessary. So we'll hit that, Dolly, here after break. And Texas, Dalen, Texas, Florida, and a couple others have the ladybird deeds. Thank you for that clarification. I had not heard that term.
No, that's new. Must have been named for Ladybird Johnson.
And then somebody put a little bit more here in the chat. Title. Okay, does title need to be under both parties before granting into the family trust? No, not necessarily. There are times when the husband or just the wife owns the property, and that can be put into their, listed on their separate schedule. When we go over the documents, you'll see there's a schedule for joint property, and then there's a schedule for separate property, sole and separate for each of the spouses. So, or each of the other persons in there. So, no, it doesn't have to be, both of them don't have to be on there first to transfer it. What happens when a home is paid off and the husband dies? How do you remove his name from the deed?
We'll talk about that.
We will talk about that as well. Hopefully they were joint tenancy or transfer on death.
Joint trustees.
Oh, and joint trustees. Oh, yes, yes. We'll talk about that as well, as far as the trust, transferring the trustee. Husband and wife now divorced, but they own a property vested as joint tenants. Can she do a living trust and leave her interest to her children?
The answer is yes, but you need to change how you're holding title.
Yes, they don't want to be joint tenants anymore. So, but yes, they can do that.
They can be tenants in common. And I've done that in divorces where there was property and one wanted to sell and one didn't. And finally the compromise was to become tenants in common so that the one spouse ensured that their child would get the property and the other spouse wouldn't try and sell it and the child wouldn't get anything. So again, all of these, I know we're talking about different things, but they are so interconnected in the life of your client.
If property is in joint tenancy, i.e. mom and kid, can deed be granted to mom as trustee and kid as a single person? Well, yes, but why would you do that?
Exactly.
It doesn't make much sense to do that. Just name the child as the trustee and put the whole property in the trust, because you're basically leaving half of the property on, what if something happened to the kid and he passed away, was in a car accident or something? Now you've got 50% of a property that has to be probated. So it just doesn't make a lot of sense to do that. But
and financially, it's better to get the property as a gift.
Yes. Yes.
Rather than now. Again, though, with Prop 19, who knows? So
yes, whenever you're adding children onto a title, you still want them to consult with a tax person at least, if not an attorney, because there are some tax consequences, possibly, definitely these days with Prop 19, the property tax itself can change, but there could be other tax consequences depending on the person. So yes, Colleen, correct, 166,250. Possible, explain one more time why you don't transfer the checking account to the living trust. Well, basically they would have to be signing every check as comma trustee.
Correct.
And when you're, when you're talking about older people, they don't get that. They don't want that. It's annoying to them. And so that's basically it. If you transfer your checking account into your trust, you have to write your name, comma trustee, every single time.
Okay, and according to NOLO,
There
it's very clear. Unless you want to pay your bills in the name of the trust, don't do it. A checking account in the name of the trust can cause raised eyebrows, even refusal to accept the check by people or institutions who wonder, why can't she write the check in her own name? What's this trust business? It's pretty clear.
Yeah. Are you saying you have to amend your trust if you add or remove assets like real property and vehicles? Yes, Ginger, and we're going to talk about that in a little bit later in the class as well. What coupon to use to purchase. Maria will have Carlo or Tracy figure out what's going on with the coupon, so we will work on that. Any real estate assets in a trust automatically trigger probate? No, the whole point is that putting the assets in the trust removes the need for probate, because they can be transferred by a simple affidavit. Again, we're going to get to transfers in a little bit and might make a little bit more sense then. But no, put all real property, including timeshares. Some timeshares is just an actual agreement where there will still have paperwork that needs to be done to transfer that into the property, or into the trust, excuse me. But then there are some timeshares that are on an actual grant deed, and you need to type a new grant deed and transfer those as well. So in every case on timeshares and things of that nature, they have people you can call, and they'll answer any questions and get you all their specific forms that they need. But a lot of times they also will charge for that. They'll charge a couple $100 to do any type of transfer. So the grantors need to be aware of that as well. Husband and wife are now divorced, but they own a property vested as joint tenants. Can she do a living? Oh, we already talked about that. We missed that one somehow. Does property need to be in CPWROS before going into the trust? What is that? I recognize that acronym.
Community property with right of survival.
Thank you. I'm like, I know that's right on the tip of my head. Okay, for capital gains, I don't know the answer. I've never had that come up as a trigger or an issue. But again, I don't deal with taxes of any kind. Nancy knows a little bit more than me
Please
on that.
consult your tax preparer
Thank you.
or an attorney.
Exactly. I send people for all tax questions. I send them away. I don't
Absolutely.
even try to answer that. I deal with words, not money, not taxes. Divorce parties can hold their own trust. Another thing with divorcing couples is, especially when they ask me, you know, and we're going to talk about that again a little bit later, when you need to update your trust. That's one of the triggers, is if there's a divorce. And those are great clients, because now you're doing the divorce, and now you've got 2 new trusts that you have to do. So we'll talk about that further. If the property that there's, if you have property that is not in a trust, would it trigger probate, even if it has a low value under 166K? Yes, it still triggers some type of probate, but there are some simplified probate procedures that maybe you don't have to go to court at all, or maybe you do, but you just have 1 hearing as opposed to 2 or multiples in a full-on probate. But it does still have to be probated, and a lot of times it still has to go through court. You still got to get a case number and things like that. So,
and that behooves your couple, your client, to tell you when they buy some new property, because they want to get it into that trust. You amend the trust very simply. You help make sure the grant deed is done and recorded, and it's done. It's very simple.
Yes, and Colleen's making mention about, keeping your checking account in your name, but opening separate accounts if they have large amounts. I do recommend that to my clients as well. I tell them if they've got a large savings, we may want to put the savings account in the name of the trust, or if they're going to open a money market account with the bank, things like that. Financial accounts some financial accounts can be put in the name of the trust, but again, there's a lot more paperwork involved. And if we're dealing with older people, less is more, and it's easier just to call and get beneficiary updates than it is to rename their entire account. They're going to get a new account number, put it into the name of the trust, but it is possible. And if you have someone who's wanting to do that, then you can definitely do that for them. So, all right. Well, we are just a few minutes away from taking our break.
We could take it early.
Yeah, I say we do, and we got that. Okay, so we're going to go ahead and grab a break. We're a little bit early, so we'll give a couple extra minutes here. We're going to come back at 10:30, just a little bit over a 15-minute break. And then we're going to get into the initial and successor trustees, changing the trustees. Then we will get into the beneficiaries and what type of beneficiaries. We'll also go over the questionnaire real quickly and just kind of show you guys what that looks like. Then we'll take a lunch break and come back for getting into the documents themselves. So enjoy yourselves. We're going to stop recording for 15 minutes. Zoom recording. And just wanted to catch up on a couple last things in the chat. Janet let us know that the organizations such as the Humane Society can set up an animal trust. You can fund them to care for your animals. That's great information, Janet. Thank you for sharing that with us. That's something that I hadn't really thought about much. And she posted again. But yeah, but that's very important. There's many times that you need to provide, either pay somebody, compensate somebody for watching your animals for lifetime, or just the expense of the taking care of the pets themselves. So thank you for that. I'm going to go ahead and we are going to jump into the trustees. But before that, I want to go ahead and talk about the questionnaire. So give me 1 second while I get this shared on the screen so that everybody can look at it. Here we go. So you all should be seeing our questionnaire here. Get this out of the background. Let me get this out of the way. Oh, goodness. Sorry. Okay. Oh my gosh. It's going to get everything there. Okay, so just kind of wanted to go over the questionnaire. We have a little extra time in this section, so I wanted to spend a few minutes on this. This is from the CALDA website, and a lot of people have their own. That's fine. You guys can share amongst yourselves, but this is the one that CALDA provides.
And it protects us.
And it does protect us. It's got everything you need to ask. We also were just talking about NOLO has a checklist as well in their books. So, so the information's there for you guys in any of the capacities.
Should you do a contract? Should you do a contract? Is that what I want? Calda's contract, it says, you know, for X number of dollars, I'll do this.
The living trust? Yes.
Yeah.
Yes, absolutely.
So you should do
Contract for
that before
everything.
you do this.
You basically, and a lot of times they're done together. You know, they're
Yes.
signing the contract and you're going through the questionnaire. A lot of people have the grantors, the clients themselves fill out the questionnaire. That is ideal because then it's in their own handwriting if there's ever a problem later down the line. But we are dealing with trust, and a lot of times we get older clientele, and so you may have to assist with that a little bit. And if that's the case, you can put a little disclaimer or have them review it and initial sections, whatever makes you feel comfortable for your liability purposes. So
good.
So here we just go through the personal information, stating their name, their socials, their dates of birth, address, home telephone, cell number. I usually get the phone number, you know, remember everybody's got cell numbers now. So usually the spouses even have different phone numbers to list. We want to find out if they've got a will or a trust now. And then this first section involves their children, any children that are born or adopted to you. I also get their dates of birth because we list that on the will. I do list the children's dates of birth on the will. Information pertaining to grandchildren. Now, if they aren't leaving anything to the grandchildren, you don't necessarily have to have them go that next level. But if they are, you know, if one of the parents pass and it's gonna go to the grandchildren, or if the grandchildren, the grantors themselves are leaving things to the grandchildren, yes, you need to get all that information from them as well. Who will step in upon your passing? This first section's for the executor. They're usually the same. To avoid confusion, I would always have your trustees and your executors be the same. So we've got Jane Smith and Judy Smith here. And then guardians of the minor children, same thing. Trustees of the minor children. And here's where we talked about that you can actually set different age limits for the children. So you can keep their custodial account where it will end at 18 when they become an adult, or to 21, or you create a subtrust that can go much longer and until they reach a certain age. Section 3 is all about your beneficiaries and your heirs who you're leaving things to. Alternate beneficiaries, here she just said redistribute. We're going to talk about that with the beneficiaries. It's always important to have alternates. Special gifts to organizations. You want to leave something to the SPCA or a church. A lot of people want to leave a gift to their church. Those type of things, they're going to write that information in here for you. And then special gifts to individuals. We've got some samples here. These are great samples. Have them list those all here. I also do include, and I'll show that in my miscellaneous forms, when it comes to personal assets, if somebody wants to leave a serving dish or something, and maybe they're not sure right away, but they can actually add those things into the trust with that personal property list. But if they know at the time that they're doing the trust, I put all that in there. If they're leaving their china to a certain person or this or that, I put all that in the trust for them. Disinheriting, we'll talk about that further, but you definitely need to cover that question with people. And do you want to forgive any debts upon death? Don't have this happen very often where this comes up, but if somebody owed the grantors money and actually had a promissory note or something like that, they can forgive that upon their passing and forgive any debt. So for living trust only, it's kind of redundant because this is basically for the trustees. So they're going to be the same as the executors. So you can use either section there. And then this is all the property that that you need to list. So house, car, boat, bank accounts, investment accounts, except anything we have the beneficiary for. So there's some, I list everything for the people, even if they have beneficiaries, and I will even make a note that this is a pay on death account, or I tell them, maybe put a copy of the statement in the binder. So because not only are we creating the trust, we're trying to create a safekeeping place for them to give everything to their trustees in one fell swoop. So they're not looking through all of their parents' mail, trying to figure everything out. So even if they have a beneficiary listed on them, I usually tell them, put a copy of the life insurance policy in your binder and put all these things. I give them a miscellaneous tab for that, and I would encourage your clients to do the same. Final arrangements, this basically gets covered in the power of attorney as well, but I do talk about it here. If they have a cemetery or a crypt, where is that located? You want to know any of those, that they prepaid for anything, that'll get included as well. All right, so.
And the interesting thing on the questionnaire is you get questionnaires back with this limited amount of information. Again, like I was saying earlier, as you sit down and start talking with them and things start coming out, more information comes, you can add it to this before you agree to do the trust, before they sign off on everything, because they think they don't have a lot and they're not even sure why they need a trust because they only own a house and a couple of cars. So again, this is a great discussion document as well, and you will get a lot more information than what they put on there originally.
Agreed. All right, we're going to stop sharing there. I got a little, okay, we're going to transfer over a little bit anyway, because we're going to go ahead and jump into the initial and successor trustees. So, all right, so starting out, the initial trustee is the grantor. They're interchangeable terminologies, grantor, trustee, initial trustee. They are the ones who are going to be the first trustee. If it's a couple, it'll be, you know, both of them. If it's a single person, obviously it's just one. The responsibilities of the trustee, the initial grantors, besides setting up the trust itself and making sure everything gets funded, there's not any formal record keeping that needs to be done or anything of that nature. So there's really not a lot of paperwork or day-to-day work that they have to do in order to ensure that the trust is kept up. They do want to do a review on a regular basis, especially if there's been life changes. After the death of one of the trustees, the other trustee shall serve alone. That's the way that the NOLO template is involved, and that's the way that most couples want it. There is every once in a while, say that an older person, maybe they're in their 80s already, they're already having trouble taking care of their finances, they can go ahead and appoint a co-trustee right off the bat, so that it's the grantor and maybe there's a child or something as the co-trustee. Most of the time that's not going to happen, but there are those cases that could come up. Then they're going to name their successor trustees. Some thought needs to go into that. You need to make it clear that, you know, they're going to have any successor trustee that they appoint will be the ones in charge of distributing all the property. They hopefully are the peacekeeper of the family, and is going to keep everybody calm and do everything in a timely manner so that people are getting notification of the trust and of any distribution and things of that upon the grantor's passing. They play a vital role in carrying out all of the instructions that are in the trust, so you want to make sure that they are going to adhere to your terms and that there's not going to be a contest of the trust. You can name, a beneficiary can be named a successor trustee, and in fact, probably 70 to 80% of the time, that's the way it is. The children are named as the successor trustees. They're also the beneficiaries and are going to be receiving property. There's nothing wrong with that, and there's no conflict to have that happen. There are some different ways to set up the successor trustees. You could have one, you always do want alternates. So you could have one serving and then an alternate, and then even another alternate if they wanted to. You can also have them serve as co-trustees, where you have two. I really recommend they don't do more than two. Every once in a while, I'll have someone who has 3 children and they're adamant that all 3 are going to be co-trustees together, and that's okay. But you still even need to ask them at that point, well, then if one of them is not available or cannot serve, you know, the other 2 can serve alone, or the other 1 can serve alone, or do you name some additional trustees? It's almost like leaving a benefit or leaving property for someone. You want to make sure there's at least 2 layers of trustees and alternates, and maybe even possibly a 3rd.
So why do you ever ask, why do you want a co-trustee?
It's usually dealt with because a lot of times they don't want to show favoritism to one child or the other. A lot of times they just don't fully trust their children and feel that it would be better if they have to agree on things. When you do appoint co-trustees, there's also the question of whether you're going to have them act separately to represent the trust, or if all of them must sign together in order to perform any operation of the trust. If you are, if you just don't want to offend one of your children, you could have them act separately. But if you're not trusting, if your clients are not trusting their children 100%, then you definitely want them to all have to sign together.
How about appointing somebody that's not one of your children?
That's okay.
Would that eliminate that problem of not trusting? Or
well, of course, if that's somebody, you know, a lot of people do appoint their brothers, sisters, you know, their best friend. And even if they're leaving the property to their children, they'll
Right.
appoint them to be the successor trustee. That is the biggest point that you want to make to your clients. It needs to be someone that you trust. And then, you know, sometimes people don't have anybody that close, and that's why their kids, they'll put them on all as co-trustees because they figure that kind of eliminates the problem. And it does for the most part. If everybody's involved, they all have to work together in order to, you know, to transfer the house over to them or to get the money from that bank account. So they're going to work together and do that. But choosing anyone you want to be a trustee. It does not have to be a beneficiary, does not have to be your children or your heirs. It can be completely somebody unrelated. There are instances where they have no one to appoint, and there's fiduciaries who, and that opens a whole nother thing, but there are fiduciaries out there, although sometimes that is sticky because most fiduciaries want your estate to be worth a certain amount of money before they will agree to be the successor trustee. So those are things you'd have to look into, and we won't delve too deep on them. If you have specific instances of that, you know, we can certainly help out in the future. But most of the time, people have someone that they can leave or they can appoint as their successor trustee. Again, we spoke a little bit about alternates. You want to make sure you have alternates, or you clarify whether if one of them can't serve, the others can serve by themselves. Out-of-state trustees, you can name out-of-state trustees. They don't have to live here in California, but you do want to remind your clients to think about the logistics of things. We are in the digital age, so it's a lot easier than it used to be, but there are times when not having somebody here locally who can come secure the house or, you know, get help meet the heirs and divide up the property and things like that may be a bigger headache than it's worth. So, and you might need to think about, you know, should you allow the trustee to have to be compensated for travel expenses if that's the case. So there's more involved if you do an out-of-state trustee, things to think about, but you can do that. Your clients can do that. And we talked about naming more than one trustee. So some of the responsibilities of the trustee is, of course, distributing the trust, notifying the beneficiaries. Excuse me while we get situated here. So usually the trustee is going to start out by getting lots of certified copies of the death certificate. They're going to go ahead and let's start with the surviving spouse. First off, if it's just the surviving spouse, there's really not a lot that they need to do. They may need to do an affidavit of death of trustee. So what they're called, yes. And that's just an affidavit that gets filed and recorded. They'll attach a death certificate to that. There's templates all over the place for those. You can get them from Sac Law Library. You can just Google it. You'll find a template for an affidavit of death of trustee, and that will take the one grantor who has passed, take them off a title and everything at that point. But once both grantors pass, there's a little bit more that needs to be done by the successor trustees who step in. They're, like I said, get the death certificate, start getting ready for that. They're going to also be notifying the beneficiaries. There is a statutory form that they can send out. I have a sample of that in our miscellaneous stuff, so I'll show you that to you in a little bit. And there is a step-by-step way to do that. You notify the beneficiaries. You're going to want to give them a copy of the trust. and send out the statutory form that has language in there that they have 120 days, I believe, to contest the trust, or ask any questions on that. At that point, then the trustee can go ahead and start distributing the assets from the trust. Some of the other responsibilities that the trustee is going to have is preparing and filing any estate tax returns. They need to make sure they've got a good tax person available and go through all of that. One of the biggest responsibilities of the trustee is if they find that the grantor is incapacitated. So first off, NOLO recommends that you have 3 people that, and 2 of them have to agree in writing, and that's written into the trust document, into the trust sample. So, and they actually, NOLO recommends that you do not have the trustees be the same people who determines incapacitation. Which that was new to me. That was a new suggestion. Every time you read this book, you get new ideas, because in most cases in the past, they've had the trustees be the one, but that's a little bit of a conflict of interest. So if at all possible, the grantor should have 3 different people aside from the trustees that would determine whether someone was incapacitated and not able to take care and manage their finances. If that's the case, they can prepare an affidavit of successor trustee. The successor trustee can step in, and now they're the ones who are signing, paying for bills, transferring money around, whatever's necessary to take care of that incapacitated grantor. And when you, in most cases, we don't pay the trustee. A lot of times the trustee is one of the beneficiaries in most cases. So you don't pay them a separate fee or any type of statutory fee to manage the trust. However, you can. It's available to them. You can pay them a flat amount to put that into the paperwork, or you can pay them the statutory fees that are listed in the code. You definitely are going to want to pay the trustee if they're going to have to manage a child's trust, or if the grantor becomes incapacitated and is going to be managing the trust for a long period of time. At that point, you may even want to have something laid out in the trust stating that. In NOLO's sample, it does state that there's no compensation for the trustee. But again, if you know for a fact that they're setting up a child's trust right then and there, you're going to want to think about that and determine whether there should be some compensation paid or not. And the trustee's authority and their powers. So in the paper, in the documents, when we get to them, there are 13 different powers that are laid out for the trustees. And it's basically allowing them to to finance the home, to transfer property, bank accounts, talks about safety deposit boxes, talks about all those different things. The trust gives the successor broad authority to manage the trust and to and even manage a children's trust. It includes health support, maintenance, or education for children's trusts. So again, that's why they talk about compensating a trustee for managing the children's trust. There's going to be many times they're going to have to get involved and make payments and make decisions on whether they should be removing funds for the trust to pay for any education expenses, health expenses, or maintenance for the benefit of their life. The successor trustee is to act responsibly. They are basically taking on a fiduciary role. And as long as they are acting responsibly, they can't be held liable. If they were to make an investment and it was a sound investment, it's on the stock exchange, or, there's plenty to back it up, and that invested tanked, that company went downhill, that they can't be held liable for that. That was made in good faith, and it was made based on good information or a suggestion through a financial person. However, if somebody's willy-nilly or decides that I'm going to invest in my own company and get this off the ground with that, they're really opening themselves to some liability and down the line, and they can be sued for that. It's a breach of their fiduciary responsibility. So again, a lot of power and authority involved in being a trustee, and we want that to be relayed to your clients when you're talking about that they're giving them authority to to manage their finances and be, it's just like a regular power, basically like a power of attorney. So should be, that information should be relayed to the clients in that manner and how important it is. We talked about paying them, and again, notifying the trust beneficiaries is a big part of it. You want to know if there's anything that has to, if anybody's going to have a contest over anything, they can get that brought up right away. And we talked about the 13 powers, and we'll go over those more in detail as well. So changing the trustees, what documentation is necessary? So some of the documents, so for changing the trustees, there's basically going to be affidavits that are done. As we talked about, there's affidavit of surviving trustee or death of trustee. The affidavit of the successor trustee must also be recorded. So once both grantors pass away, the successor trustee, when they step in, will fill out that form. Again, that's available through the Sacramento Law Library, or just Google it. It's anywhere. If anybody ever needs a copy of one, they can reach out. I'd be happy to send them one. It must be recorded. It must be notarized. It must have a death certificate, an original death certificate attached to it, and all that gets recorded in the county where they own the real property or where they're living. If there are resignations, and say that there's a trustee that wants to resign or and cannot act, it should be written. I would recommend that they have that notarized as well, although it's not necessary. It's not the law, but again, I would always recommend anybody have anything notarized so that there's no problems later. But they would want to write that they are resigning as a trustee. There is also power to appoint successor trustees. That's written into the living trust and NOLO's template of the living trust. So if for some reason all the successor trustees have either passed or no longer want to serve, sometimes that happens, especially if the trust has been valid for a long period of time. They need to put it in writing, and then the very final successor trustee can appoint someone. But those are responsibilities of the trustee, and to not leave the trust without a trustee that can administer and take care of things for the beneficiaries. Worst case scenario, I would go to one of the beneficiaries and ask them to be the trustees so they can at least distribute the trust to themselves if necessary. The trustees, yeah. So let me see if there's any questions on the trust, or do you have some?
No, go ahead.
We're going to look and see if there's some questions. Can you repeat that about taking a person off the deed?
We can do that at the end.
Okay, yeah.
Because we're going to go over the details.
Yes, I agree. Okay, and they were talking about no trustee available, corporate trustee should be appointed. Yes, that's what we were talking about. But you do need to be careful with that because, like I said, a lot of these corporate fiduciaries, your estate has to be a certain amount. So that can cause complications. I'm actually finding and working with my estate planning attorney that is a huge area that's open for, with a huge need, becoming a fiduciary. So if you've got a strong background in that type of work, if you've got, no bankruptcies and you've got a strong, solid financial background, you may want to look into that. There's a huge need. It's a test that you can take through the state of California to become a fiduciary. And that also works for powers of attorneys and administering estates, going through probate and things like that. So just a little sidebar that that's an avenue if you're interested. Sure. And maybe could help more people out, because there's many people who don't know who to appoint for the trustee or their powers of attorney or anything of that matter. Right, so we'll talk a little bit about the beneficiaries then and the different types of beneficiaries.
All right, there we go. Okay, beneficiaries. Wouldn't it be nice to be named a beneficiary in an estate? It would, but it could have some other issues with it. So we're going to go over the different kinds of beneficiaries that NOLO NOLO talks about. There are primary beneficiaries, whom you name to receive property. Primary beneficiaries include individuals, institutions, and groups that will receive your property. There are alternate beneficiaries, whom you name to receive the property left to the primary beneficiary if the primary beneficiary predeceases you. And then there are residuary beneficiaries who receive all the trust property not left to the primary or alternate beneficiaries. You can, if you choose, leave all the property to your beneficiary and not name any primary or alternate. And I've had some clients do that because it's all going to go to the same person anyway, so why should they do that? But you want to keep it simple. You can get really bogged down in, if you name, we'll go into that, but you want to be clear who your beneficiaries are. Beneficiaries are those who inherit property. They're not liable for federal income tax on the property. Of course, with very large estates, there may be a lot of tax issues, so you may want to refer them to an attorney or an estate planner. If the gift generates income in the future, the beneficiary is responsible for paying the income tax. Personally, I was the recipient of, I was a beneficiary, and it took 6 months to collect the funds. And I thought, great. And then I found out I had to pay income tax. Well, I was not happy with that. But then, as my brother pointed out, we were only paying income tax on the interest it earned in those 6 months, not on the main benefit. So you need to make sure that people understand there are some financial considerations for this, but in the long run, it generally works out pretty well. We talk about, those are the different kinds. So you name your children, and I think in our sample, I forget who we named them, but Johnny and Susie are your main beneficiaries. They're going to get everything 50-50. But what happens if Susie predeceases Johnny? Does her share go to him, or does it go to her heirs? And that can get really sticky sometimes, because is it going to be a good thing for Johnny to be in business with her children? Or are they just going to split the property and go their separate ways? These are discussions you need to have with your client, because they certainly have not thought of that, because their children get along and everything is just peachy. But if they choose not to give Johnny's share to Susie, then how far down is it going to go? And are there in-laws involved, like a spouse of the predeceased person? So those are the things you have to think about. Also in beneficiaries, and this is a real fun one, disinheriting your child. I had a client come in, they sat there, they were all ready to do their trust, except dad wanted to disinherit the son and mom did not. And so I sat back in my chair and watched them discuss this, and they could not come to a conclusion. So I suggested they go home and think about it instead of sitting in my office debating it, and see what they wanted to do. And they couldn't come to a resolution. And I said, if that's what you want to do, then we'll do 2 separate trusts, which that was not their plan. Or I found out that their son had borrowed a lot of money and never paid anything. And their other child had done everything right, was the great kid. And so I suggested they might want to think about giving him a very small amount of money, not disinheriting him, but writing a letter that's attached to the back of the trust that says, "Dear Johnny, you borrowed $50,000. You never paid it back. You've already received yours. Love, Mom and Dad." Number one, you're helping your successor trustee not be the bad guy, which takes a lot of pressure off. Number two, they can rant and rave all they want, but you did leave them $100 in there. So he can't go to court and say they meant to give me money and they didn't, because they did. And I don't get much deeper because then you're getting into areas of law that I think you should have them go talk to somebody else about. So it's up to you. But what they finally did was did the letter. Dad acquiesced and did not disinherit him. And the other prevailing reason was, do you want this to become public that you disinherited your child for something that was nobody else's business? And this could become public. So how do you want your children to see how you finished your life by doing this? Is that the thing they're going to remember? So there are lots of issues that are very personal. So you need to let them talk and also be there to help facilitate the discussion. And sending them home sometimes is really a good thing. So you have other options available. One suggestion is if you have grown children and you have other things that you want to consider, again, percentages. I really recommend that. One client gave each child 21%, then they gave their grandchildren 7%, then they gave her brother 14%, and then a charity got 9%. Those are different numbers, but it adds up to 100%. And no matter what she had at the end of the day, they all got something, and they knew that she was thinking about them. Another beneficiary situation is a couple owns property together, and the wife names her husband as the beneficiary of her share, and he names her to inherit everything except his half of their family cabin, and he wants his half to go to their son. So down the road, mom and son will own the cabin 50-50. But that's how they wanted it, and mom was okay with it, so everything's good. There are some things about simultaneous gifts, and that gets to be a little sticky. The statistical probability of simultaneous death is very low, but still it's one of the first things many couples ask when preparing. What happens if we're both killed in an accident? If you leave all your trust property directly to your spouse, your trust document doesn't have a clause to cover simultaneous death. You and your spouse are considered to have died in circumstances that make it difficult to tell who died first. So your property could pass to your spouse and then immediately to your spouse's inheritors. That may not be what you want. So you need to think about that, and NOLO covers that very well. Then they talk about shared gifts for your beneficiaries. What percentage of ownership will go to each? What happens down the line if the beneficiaries can't agree on how to use the property? And what happens if one beneficiary dies before you do? I've had several of those. So they've come in and either amended or rewritten the whole thing because the trust was so old that they needed to redo it. You can do percentages. You can give your children, again, a certain percent. Or you can, and I'm having a lot of people now talking about grandchildren and not necessarily bypassing their children, but the grantor's grandchildren would be given a house. 40% would go to one, 30% to another, and 30% to the other. It's all about what your client wants, but you've got to listen. And there are going to be conflicts. If you, again, like Jenny said, what if somebody doesn't want to sell the property? Then they're going to have to figure out how to buy the others out. And then you get the probate referee in there, or you can get an appraiser if you've got a local one. But if you've noticed anything lately, finding real estate appraisers in this day and age is very, very difficult. So you might start wanting to get those people in your list of people to call in the future and who will take your calls. There's a lot of conflict when you get to some of this, and people get really bent out of shape about what they're getting and what they're not getting. The question earlier about somebody finding out that they weren't getting the same share, number one, you want to find out how they found that out. And number two, maybe you want to do a letter and attach it and say, look, this is why I determined this. And the best line I have for my clients when they're getting close to being done is saying, you know, after you're gone, you're still mom and dad. And what you want is what's going to happen. And for some reason, that seems to give older clients just a little bit of thrill to think they can still be mom and dad even after they're gone, because these are their wishes and these are the things that have to be carried out. So then you talk about some common concerns, like if there's only one beneficiary and they pass away, then what? Jenny touched on that earlier, and we can talk about that some more. Married beneficiaries. Suppose your children are married and you don't like one of your in-laws. You could leave your property to your child as their sole and separate property. And as long as they don't put it into their community assets, it remains their sole and separate property. But the minute they commingle it, it becomes community. And then that's a whole nother issue with a divorce, perhaps. So you need to make sure that people understand how they're giving this property to their children to make it easier for them. But if they see war clouds on the horizon for one of their children, be very, very clear about how they want title given to this child. Children from prior marriages. I imagine a lot of you are seeing that. And you, one of you may not like the children from the prior marriage. You can leave them gifts outright using a shared trust. You can create a more complex trust, but you need an attorney for that because this could probably end up in court. You need to see an attorney if you anticipate any kind of conflict between a surviving spouse and the children. I don't know that I would want my house to be owned 50% by stepchildren, and I have to live there and I can't do what I want with my house that I have lived in for 30 years. Help them have those conversations. Help them see how that can work. Again, NOLO is for the layman. So these are really good discussions that they don't have to pay by the hour for. And that's another reason why LDAs are so important. Unless you're charging hourly fees for your client, you're going to learn a lot, which is going to help them avoid a huge problem down the road. Another beneficiary might be minors or young adults. We're going to talk about children's trust, and that's a minor under the age of 18. And then who your successor trustee as a beneficiary might be. And some people think, well, that's a conflict, but it's not, because when you have your trustee hat on, you're acting on behalf of the trust. When you're a beneficiary, you're receiving. And so you talk about the grant deed that the successor trustee may come in with to transfer property. And some people get all upset going, well, his name on there and he's giving it and he can't do this or that. And you have to educate them about what the job of the trustee is and how they can transfer the property, even from themselves as successor trustee to themselves as the beneficiary. Pets, we were talking about that earlier. More and more pets are part of the family, and you want to make sure that they're cared for. But like Jenny was telling me, she has 2 dogs, that she doesn't know how many people would want her 2 dogs. But then again, you want to provide for those dogs. So you need to think about who might receive those dogs and how much money you might want to give them to maintain those pets. I had a cat that lived to be 20, you know, who would have thunk? So you can't leave property or money outright to a pet. But if you name the pet as a beneficiary in your will or living trust, be prepared for some other issues. But it's a costly and complicated process to simply leave your pet, your assets. So you definitely need to talk to an attorney. Then naming alternate beneficiaries. You're leaving money to your 3 children. What do you want to happen should one of them predecease you? Do you want it to go to the 2 survivors, or do you want it to go to that deceased child's family, heirs? That can get a little sticky too, but if you don't name it, if you don't say it, it's going to be an issue. So naming alternate beneficiaries can be sensible for a number of reasons. You've left property to older people, or they're in poor health. You're a cautious person. You don't want the bother of amending your trust documents if a beneficiary dies, and that's a big one, because if that beneficiary passes away, the alternate now steps up, unless you've said that it's going to the survivors. So those are naming alternates, and you can name alternates to the alternates if you want. But by then you're wondering what's going on and what kind of estate these folks have. And if they have that large of an estate, I personally send them to an attorney. I just feel like I may miss something that could really throw a wrench in the whole deal. And I have found that I sleep better knowing that they've gone to an attorney and taken care of it, and that's not my responsibility. If you don't have any person you want to name as an alternate beneficiary, you can do some of the following. A single mother had a son. He was her beneficiary, and there was no one she wanted to name after her son. The problem in the situation is that if tragedy strikes, the son dies first, and there's no alternate to her estate. And it could end up with relatives to whom she would not have wanted to give the property in the first place. So help them think about another alternate. And they might consider naming a charity or a cause they're interested in. I have sitting on my desk right now 2 checks made out to a private school and to the local pet association that a woman who had not seen her children in over 60 years and didn't even know where they were, basically, left some money. And I am the one now to take those checks to those organizations. There are ways to do this. And you can name more than one alternate beneficiary. So it depends. And this was the example Jenny and I were talking about earlier. A couple left a nice estate. They had 2 children, and they wanted to leave money to both of them. However, they had helped pay many thousands of dollars to help a daughter through medical school. And the other daughter had been self-supporting since she left home. So they decided to leave 75% of their estate to the daughter who was working and 25% to the daughter who they had helped through medical school. And they stated why, and it was very clear. And they felt very comfortable naming that. Things get pretty complicated if you decide to move to the next level of co-beneficiaries. And if you're going down that road, never mind. You don't want to do that. You can provide for a deceased child's share to be shared equally with their beneficiaries, or to be going back into the collective pool. I was amazed to read imposing a survivorship period. Back when I started being an LDA, it used to say things like they had to survive you for 30 or 45 days or something like that. And I don't see that much anymore. But you can do that if you want. And the reason to include a survivorship period is if a beneficiary to your property dies soon after you do, the property that you left to the person will go to his or her beneficiaries. With a survivorship clause, in order to pass that property on to someone else, a beneficiary must survive you for a certain amount of time. The trust forms in NOLO do not impose that time period on there, but it's something you may want to think about. And the example is, a woman left her trust property to her husband and names her daughter from a previous marriage as an alternate beneficiary. They are both husband and wife seriously injured in a car accident, and he dies 4 days after she does. Because he did not survive her for 15 days, the trust property he would have inherited from his wife now goes to the daughter. So there are a lot of little nuances there. You may not want to do that, but I want to point out that it's there. Again, residuary beneficiaries of a living trust for a single person. Think about that property, any property that you leave in your trust through the will becomes property that can be transferred. So you've got to think these things out. And then again, we talked about disinheritance. And I did not know that you could consider disinheriting your spouse.
I didn't know that either.
Why you would want to do that, I'm not sure. But in some places you could. I would assume that might be a second, third, or fourth marriage, but one does not know. So you need to be sure that you understand what the thought is behind that. And again, if you're feeling any twinge on that, send them off to an attorney. Get that legal advice. It may just be they're mean, and that's the bottom line. Another beneficiary is unmarried couples, because California has registered domestic partners, and now almost all marriages are now legal. So they can, unmarried couples living together have no rights to inherit each other's property unless they're registered. So you need to find out about that. But there is a book called Living Together, a legal guide for unmarried couples. So you might, if you have a larger clientele of that, you may want to look into that. Let's see, what else? We talked about disinheriting. A new one that I've seen in the news also is children born after the will or trust is prepared. You want to make sure that you've included language that includes any child born to or adopted by me after this is done. But another one is posthumously conceived children. And if you follow the news, there are several high-profile people that have done that, and then the war begins. So you may need to send that also to an attorney. It's a real sticky thing, and the laws change. Grandchildren have no right to receive property from you or to inherit, but you can do it and enjoy doing it, but they don't have the right. And then there are general disinheritance clauses. You may have heard that some lawyers recommend leaving $1 to close relatives in your trust or will. This is not legally necessary. And it's a bad idea, and here's why. There's no need to mention anyone but your spouse and perhaps your children in your trust. No one else has a legal right to any of your property. Moreover, your successor trustee must track down each beneficiary to whom you leave $1 and procure an acknowledgement that the beneficiary received that $1. That's a lot of work, and there's no point to it. So I do have older people coming in asking about that, but again, you just provide them with the information. And then you can head off some relatives, maybe, with the no contest clause in a living trust. And it's a device used to discourage beneficiaries of your trust or will from suing to void the trust or will and claiming that they're entitled to more than you left them. Under the no contest clause, a beneficiary who challenges a living will or trust forfeits all his inheritance under the document. Without a no contest clause, someone left property from a living trust can sue, lose, and still collect the amount given to him or her in the trust. So it's tying it up, and the expense is tremendous, but that's up to everybody else. So a no contest clause can be sensible if there's a risk of a beneficiary might challenge your estate. I have one currently where one of the siblings is suing the other one for not distributing. Well, she did, and she has the receipts. but they're going to court next week for this. And it's just to tie things up. So you never know. And then finally, putting conditions on your beneficiaries. Occasionally, a person wants to make a gift with restrictions or conditions. The trust forms in this book don't allow you to make those conditional gifts. So you probably just don't want to do that. And then what about property that's no longer in your trust at your death? If you make a gift of specific property to your trust and then remove it before you die, you sell the property, you gave it away somewhere else, the beneficiary for that gift will probably be out of luck and is likely to be quite upset if he or she knew about the request. So if you do transfer property from your trust, be sure to amend your trust documents and formally delete the provision in the trust. Then we have worksheets, and they have great worksheets in here helping you to think about individual living trusts, shared trusts, who the specific gifts are going to, what it is, and why you're giving it to them. It just helps think things out. Then, we're going to talk about this later, but I know there's a question out there saying, we thought we were going to fill out documents or this was a form situation, and we're going to do that after lunch. We have samples of everything, and we're going to walk through NOLO's suggestion of how to do this in a simple way. So I think, are we going to look for some questions?
Yeah, let's take a look at the questions before we break for lunch. Let's get caught up there. 1 second. Trustee is administrative position, beneficiaries completely separated. Colleen was making a clarification. To be clear, the trustee is an administrative position and beneficiaries are completely separate. Sometimes clients or their families are confused about that. One has nothing to do with the other. They are two separate designations, and that's absolutely true. And I think we talked on it a little bit more. They don't have to be the same person. The trustee has a responsibility to administer the trust. They take on a fiduciary role, which the beneficiary does not. They just sit back and wait to get their property. So absolutely, they are two different positions and should be explained that way, because they don't have to pick the same. They don't have to pick a beneficiary as a trustee, or vice versa, quite frankly. So can you repeat that about taking a person off the deed?
We can do that if we want.
Yeah.
Okay, so I'm not sure, is this someone that's been added prior to doing your trust, or is this someone that has passed away? If they passed away, you do an affidavit of death of joint tenant. If they aren't in a trust or as trustee, you fill all that out, attach a death certificate and record it in the county, and that removes them. If they're on there with you as a joint tenant, you need to have some discussions. If all else fails, I've sent them to an attorney, and I found out that they can change the grant deed from a joint tenant to tenants in common. And you can do it that way as well. But I'm not sure that is the question, but those are two answers we've got.
And if a person only owns 50, if say there is shared property and one person wants to do the trust, they can transfer their 50% into the trust and make their 50% a trust. Right. There'll be a new grant deed. You both need to sign for it, but you can put their 50%, and that would basically sever any joint tenancy at that point anyway, because you're creating it into two separate entities. So as opposed to joint tenancy. So I don't know if that was answer to your question there. Mona Velasquez. California code allows 1 to 5% of the gross assets under management annually for the trustee to be paid. So if you state the compensation is reasonable, the statute may come into play. Thank you, Colleen. That's perfect. Thank you for that clarification.
And it leaves it open because we don't know what it'll be when you pass away.
Right. And or how long you've had to administer the trust, say if somebody was incapacitated. And again, even talking about compensation for taking care of pets and things like that. Those are all things to be thought of. Does NOLO have guidelines for witnesses to determine competency of the trustee? I am not aware of any. Dalen has put the Professional Fiduciary Association of California. Thank you. That is what I was talking about. If anybody was interested in becoming a professional fiduciary, that is an avenue that's out there. And
Physicians.
oh, the physician for the capacity. Yeah, okay, that's a good idea.
And you have, surely there is an adult child saying, Mom and Dad are not capable of making these decisions. There's something wrong. I send them to their physician and let the physician do a form that they have that says they are not competent to make these decisions. And then you can go from there, because you've got the physician making the determination, and then the successor trustee can step up
and can agree with the physician. It's not necessary to have a physician. The way that the wording is,
right?
The 2 out of the 3 just have to agree that the person is not, and it has to be in writing. They have to write. So it would be a good idea to have provisions in there as to why they don't think they're competent. That, you know, they're buying all kinds of stuff. They've been subject to fraud. You know, write these reasons down, keep them in the trust binder. In case there's ever a contest by a beneficiary later or a problem down the line, the trustees are backing themselves up. But definitely going to a doctor, especially if they have a primary physician, and having that conversation with the doctor. And so then taking their letter and then attaching, yes, we agree with the doctor, and find
Perfect.
that they're not able to manage their trust anymore. It's all CYA. And again, because they are a fiduciary, they want to take any steps necessary to make sure that they're covered from a lawsuit later down the line by one of the beneficiaries.
And it also makes them not be the black hat with the rest of the family. You said that Mom was not competent, but here's the doctor saying she is not capable of making these decisions. It's not you, then you're just getting supporting evidence. And the family can dispute with the physician. So, you know, if they're going to do that.
That's very true. Maria was saying, can we suggest, is it legal? Not exactly sure what you're referring to, but you can make suggestions on different ways for them to provide to a beneficiary, or what type of trustee. I mean, you can provide them scenarios of other people that have come to you with the same type of issues, and provide them different ways that those people work those situations out. That's not legal advice. That's just giving them suggestions. They still have to make the final decision on how they want to do it and report that to you. And if they're concerned about the legality, that's when you get them in touch with a estate planning attorney. You're not going to tell them, well, that's not legal or that is legal. We have some basic guidelines, and if something seems to be red flagged or over the line, send them to the attorney to talk to you about it first. So.
And using the questionnaire, if they want to do something different, have them put it on the questionnaire. Even if you've already gotten a questionnaire for them and it's coming up, add it to the questionnaire, have them put it on them themselves and initial it, and it covers, because you're doing exactly what they want, not what you want.
Exactly. And Julia says, like family law, we are therapists too. Exactly.
Very good.
That is exactly it. And you pick up on things when listening to people, and being their therapist in a way, and counseling them, because that's a lot of times where they don't tell you things when you're just specifically asking questions, but it will come up in these conversations. And so always be listening, even when they're droning on. Do your best. Do your best, be listening for those little nuances that they say that you're like, oh, okay, wait a minute, you mentioned what are you going to do about that? Or how do you want to handle that? And help walk them through. Leticia asked if you can repeat the mom and son cabin scenario. You have that there with you, Nancy.
Yep. Go ahead and chat.
Okay. Couple have this is Loretta. Couple have 2 children. One is into drugs. They want to give all to the daughter who is clean, and for her to be responsible for the son and take care of him. Oh, you're going to want them to talk to an attorney. There could be a special needs trust that could be set up for them, or have their money rolled over, or set up, again, depending on the age of the child, you can actually create the trust or the subtrust through the NOLO trust. But that only goes to a certain age. So if this is something like a lifetime thing, you're going to want to talk to an attorney to see all the best options. If they're recommending a special needs trust, even if they're maybe not getting benefits from the state. I don't know all the abilities with a special needs trust and what they outline. So you would want them to talk to an attorney first,
Right.
unless it's just through a certain period of time, because you do have up to, what were the age limits on the subtrust, up to 30?
It can be whatever.
Or whatever, yeah.
By that point, you need something more than what NOLO will do.
Yeah, and there's a lot to think about there, because you've got to make sure the trustee is going to be able to survive, and have backup trustees so that they can continue to give money to the son out of that trust. So yeah, and I do know that there's some families where they're like, no, we give it all to my daughter. She knows what to do with it. I warn them against that, but you can't. You have to take the instructions for what your clients give you. So you may want to even write up a little something and have them initial it, just so you make it clear that they waived attorney attorney consult when they wanted to basically disinherit the child, or because that's what you're doing in that case. And if you're not setting up a separate trust specifically for that son, you're just relying on that daughter to do it. And who knows what's going to go on in her life? Who knows if she's going to get married and her man talks her into, don't pay for your brother anymore.
Right.
We need that money, So there's a lot of octopus legs with that. And you definitely want to have them talk to an attorney and just make sure they've thought of every little nuance of that.
Okay.
And cover your butt. Okay.
So she asked about the cabin. So a couple was married. They transferred their cabin to their joint trust, and she gave her share to her husband. She gave her share to her husband. He named her to inherit everything except his half of the cabin, and that he left to his son. So when he died, his half of the interest in the cabin went to the son, and the rest of it went, and Maria, the wife, remained the other 50%. So he could split it up that way. But now mom and son own the cabin together. If they're getting along and everything's good, that's great. If not, they've allowed themselves to create another problem. So it's something to think about, but they can do it, and it's legal.
Yeah.
Okay.
Including a statement of intent in the trust is very helpful and colors the interpretation of the document. Have clients author their statement of intent if you're including it. The LexisNexis software includes a place in this, but you can always add to the documents you're using if it's not in the software you use. Thank you, Colleen. Again, getting deeper into, and people who have been doing trusts for longer feel comfortable doing special things like that, and using more robust software in the future might be in your future.
I like the fact, and I've had some come back now, where the letter from the parents, it was their voice,
yeah,
and their verbiage, and the kids knew beyond a shadow of a doubt it was mom or dad saying this, and so that has helped the successor trustee a lot, because the one that was disinherited, technically, will be mad at everybody. And they will assume that the successor trustee is the one that convinced mom or dad to do this. So if you have it in their own voice, you can type it up for them, but type up their words, get them to sign it and date it, and just clip it to the back of the trust, and it's there.
Julia's asking if there's no contest clause in NOLO. They do
so.
discuss it, and I think they have it. I do also have in our
Right.
materials. I have the no contest clause is in the sample trust as well. So,
Right.
Tyler's asking if we'll be preparing a sample trust or just looking at one. Tyler, you should have received a Word document, Living Trust Shared Template. You can type along with that. I'm going to actually be going over the finished trust and kind of talking about it, but if you want to on the side be actually inputting it as we go through it, so you're step by step, you're more than welcome to. That's why we attached it there as well.
And the trust and will forms in this book do not contain the no contest clauses, but I also include that.
Yeah, and you could Google, go online. There's a lot of attorneys that put out no contest clauses on their websites, or that they wrote a paper about. You can find this stuff. You can find it at the law library and insert it into your document. be covering life estates in trust, especially for blended families. We're touching on that a little bit. Creating a life estate for a spouse is important, and a lot of people do it. That's, again, a lot of times used for blended families, just as Lori stated, where the one spouse owns the property and wants to ensure that upon, let's say she owns the property, upon her passing, that the husband gets to stay in the property until he passes. So it does need to be written into the trust that he has a life estate in the property. Not
I don't think so. But go ahead.
We're gonna look at what the NOLO guides basically say, but that is a common occurrence and something that has to be thought of, and you want to make sure you have the proper terminologies for that as well. I can't find an email for the course material. Peter, reach out to Carlo if you could help Peter with that. He's looking for the email. Oh, the discount for the NOLO program came on a separate email from the course materials. So course materials came out Thursday, and I think the discount came out on Friday. But you can reach out to Carlo or Tracy; they can help you find that. Colleen thinks it's a great suggestion on the to have the person go to a physician to determine capacity.
I've done that.
And Tyler, this is all being recorded, Tyler, so you'd have to talk to Tracy about how to download and anything about that. And different types of special, oops, got away from me. What are the different types of special needs trusts? Spendthrift trust, support trust. Okay, Peter, we're not going to get into that too much because that is where I refer to my estate planning attorney. I absolutely just don't even do it. I know there are some LDAs out there who feel comfortable with it. Perhaps they worked for an estate planning attorney for many years and have great templates for those things. I do not. And even though I do think that NOLO provides for a special needs trust, I'm not sure about the spendthrift or support trust, but I'm not going to do those. So if they need something like that, I mean, I might work with my estate planning attorney. A lot of times I do the trust and she does the special needs trust. Sometimes I just send them over, depending on how complicated the situation is, says, no, you need the attorney to do all of it, make your living trust and your special needs trust. I have not prepared a spendthrift trust or a support trust specifically on its own. Have you? No. Yeah, so I don't feel comfortable getting into that too much, Peter, but if you know some, let us know. How does an LDA find and insert a NOLO?
Back to the question on life estates.
Yes.
NOLO, they discuss it more in depth in NOLO's Plan Your Estate book, and there you're getting the verbiage that you're going to need if you want to do life estate. We'll touch on it briefly this afternoon, but basically that's a whole nother thing. So you need to look into that, but they've got a book for it. So
yes, I mean, if you're going to really dive into the estate planning, get all their books.
Yes,
just like Nancy said, they're written for the average person, so they're extremely easy for us to understand because we understand the legalese of it. It is what I've built my practice on, not only just through trust, but with their probate. With their family law books, divorce books, they cover everything, and they speak in such good plain language that you can even suggest, if you've got a client who just can't seem to answer the questions and keeps asking you for legal advice, tell them that they have to get this book and read it and then come back to you. Whatever the case may be, send them to NOLO. They're just great, they're inexpensive, and they're wonderful for people to read and understand.
If you have the NOLO book in chapter 14, it's at the end of the book, it talks about long-term trusts, special needs, the spendthrift trust, flexible trusts, and they are all highlighted with see an attorney. But they give you language, they give you an overview. But again, this is something you're going to need to be aware of. And our best advice is get an attorney you can work with that will take your calls, that will take your clients. You will save many hours of grief for yourself or your client. And the attorney thinks you're wonderful for sending them clients, but those clients are the ones going out and telling the public how wonderful you were and what you can do.
Peter asked how an LDA can insert a no contest clause into the trust form without practicing law. Do not make up your own. Go online and find one that's already been approved by an attorney or written by an attorney, and you just cut and paste that. I mean, you can put that into the trust document without that being practicing law. But I would not make the clause yourself. You want to just cut and paste from an attorney. If you work with an attorney, grab it from them. Can one replace or reinstate the entire existing trust but still keep the original trust name? Yes, and we are going to talk about that in what section? Kind of towards the very end, I think. Yes, in section 7, maintaining the trust and amendments, we will talk about restating the trust in full. So, and you do keep the original name when that occurs. So we'll talk about that more, Kathy. Thank you. This is trust will questionnaire for LDAs. Where is the trust will questionnaire form that the LDAs can use through CALDA? It is on the CALDA website.
Under brochures
and questionnaires on the questionnaire side.
So go to the member tab and right the drop down, it's right there, and go into it. All of that is in there.
Yes, and you need to be logged in. Otherwise, it's not going to come up for you. You need to make sure that you're logged in as a member.
And just as an aside, we're working to update some of those brochures and questionnaires. Because we're all volunteers and we all have our own business, it may not be as fast as we would all like, but it's being done, and we're trying to keep everybody current.
All right, and we have just a few more minutes here. Let me look at the question and answer and make sure we didn't miss anybody. That started at, I gotta look at the time, guys. So we're 10:30. Oh, I just want to, for the questions here. Okay, so can one appoint a bank as a trustee? If so, are there fees associated with this type of service? I would imagine there would be. I don't know if a bank would take on that. Again, if they have a sizable enough estate, I'm sure any bank would have their attorneys, their legal department do it. But if they've got an estate that's it's that large and they can pay, you know, that might be something that's going to an attorney in the first place. But there are fiduciaries, as we spoke about. What is the distribution method based on probate code, section 240? When is it required to refer this code? I'd have to look up the code.
Don't know.
And confirm what you're asking, Sung. What do y'all charge for a trust package? Covering life estates. That does vary by area.
May I?
Yes, please.
In the past, during our annual conference, we used to do surveys of what you charge clients for, so we could get a feel for what do they charge in LA or San Francisco as opposed to what do they charge in Eureka. It's all over the map, but our suggestion has always been, look at what's being charged in your community. Look around, talk to the attorney you're dealing with. You're not charging anywhere near what the attorney does, but you get a feel for it. And pretty soon you talk to other LDAs. And I know one year after conference, I raised my fees $100 each somewhere along the line because Ian talked about what he charged in Oakland. And I live in a small rural community and I know that won't fly, but I inched it up and nobody complained. So you start looking to what's happening in your community.
And also, as you continue to learn and become more seasoned at it, you can command a better price, a higher price, because you're more knowledgeable about situations that will come up. You've got better templates because by now you've hit all these different situations and you've had attorneys check over and you've got different templates. So again, and then by that point, you're getting a lot of referrals. So people are willing to pay the higher price. You're being referred from someone they trust. So as you grow your business and the more that you do, you're also going to be able to ask for a higher fee. So what do you consider large estate? When will you refer your client to an attorney? Explain residuary beneficiary. Now I can't say it. And what software do you use for your clients? So I'll let you talk about the beneficiary. The software, I use NOLO. I have ForTrust. I haven't cracked it open yet. So I may do that. I don't know. My attorney uses ForTrust. And got an answer on the residuary.
Residuary beneficiaries and alternate residuary beneficiaries are those who receive all trust property not left to primary or alternate beneficiaries. You can, if you choose, leave all the trust property to your residuary beneficiary and not name any primary or alternate. So they get the leftovers. But if one of them passes away, the leftovers suddenly became bigger. So it's just whatever may not be specifically designated goes to them. But if you lose one of your primary and the alternate gets everything, then you're the residuary to the alternate. So it's pretty simple. But again, the explanation in NOLO is very clear.
And what do I consider a large estate? If they have to have tax planning as part of their estate, usually what federal tax, I mean, that's like 11 million now per person. So
Really?
yeah, it's pretty high for estate planning. So if they're going to be subject to estate taxes, federal estate taxes, then I'm going to want, they've got a lot of money. I mean, that's literally would be over $11,000 in assets. So I'd have them talk to an attorney and at least have them talk to them. I mean, if it's tied up in real estate, a lot of that's real estate, it's maybe not as important, especially if they're just giving one house to one kid and one house to a sister, you know, so forth. But that is a little bit of a call you kind of have to make if it sounds like they've just got a lot of property and a lot. And again, to avoid taxes, I'm going to send them to an attorney because that's when they might need to do subtrust or do some of those other trusts that the other gentleman was naming. So,
and large trust, I think, really is the dollar amount, not the property.
Right, that's what I'm saying. It's
Yeah.
going to be over like $11 million. Even if it is just because there's
A lot of
so much real property that it's bringing it up to that, I'm going to at least have them go talk to an attorney. They may decide that the attorney doesn't need to do it. It still can be done in a fairly simplified form, but anytime that someone's going to be subject to estate taxes, federal estate taxes, because my understanding is those are quite expensive, I'm going to send them to an attorney to find out if there's a tax avoidance move that they can make. They might need to do 2 different trusts to strategize that, but there's strategy that's involved in that. So that goes to the attorney. So are we covering the difference between individual, joint, and AB living trusts? We're talking about individual and joint, not AB so much. If you need an AB trust, look into NOLO. Here in California, my understanding is the AB trusts are not used as much anymore.
Right.
I don't have all the answers for that right off the top of my head, but we are going to talk about individual and joint. The sample that's given is a joint trust because we wanted to go ahead and, you know, give you as many examples of different scenarios that could come up as possible, but the same things apply to single trusts as well. And we'll talk about that a little bit.
And AB trusts are used to control the property. And again, it comes with the see an attorney, because AB trust that is intended to impose controls on the surviving spouse's inherited property must be carefully drafted by a knowledgeable attorney. So
there you go. Will you be scheduling a probate webinar? I will certainly check with our education chair on that. There is a probate webinar in the archives that I know you can pay for, some previous classes that were done, called Academy.
Mm-hmm.
So again, you can check with Tracy and she can hook you up with the Call to Academy. There's all kinds of different webinars that were put on that are in there for no cost to low cost.
And that also helps you with the units you need every 2 years to renew your LDA.
Your MCLEs.
Yeah.
Mm-hmm. We talked about fees. What if the attorney charges around 1,500 area? That's what you to try. Oh, they're talking about fees. I'm not going to get into that more. You guys can talk together about that. Try to sign up for NOLO with Ask If Your Attorney. We'll get you some help with that as well. Let's see if there's any other questions here. We do still have 10 minutes before lunch. Yeah. Federal taxes.
Let's ask a question. How many of you have done trusts in the last 3 years? Have you done a joint trust or a single person trust?
Coming People raising their hands. 3. Yeah, just raise your hands and we'll get an idea of the hand count. There we go. So good. We're looking at least about 20 people so far. This quarter have. Answered that one. I checked with an estate attorney. He said to find a small and local bank. Okay, that's what Katie said about, I'm assuming about the fiduciary or the trustee. And that's great. I mean, a local bank would certainly, I would certainly feel more comfortable directing my clients to as well, as opposed to like a Bank of America or something. One thing, their fees are going to be high and they're not going to have the personal service necessary. So if there is a local bank that's willing to act as your trustee, they are going to charge you. They're a professional business, but sometimes that's all there is. So that's a good idea.
One thing to jump on the local bank about also is if you have people coming in and they seem to have a bank account and didn't name their spouse on it, once you get to know those banks and they know you, they will send you the customers to do the collection, affidavit for collection of personal property. They're very good about doing that. They'll call you if you're a notary, and banks can't seem to hold on to notaries real well lately. They'll call you. These doors are going to open more business for you if you start making those connections, and local banks are a great connection.
That's a good idea. David said he used to work for LegalZoom in their estate planning department. He was the only paralegal working on estate planning. Documents are unbelievably cheap. Feel free to let people know that. I agree. Like we said, invest in NOLO. So we've got the discount code, and Carlo made a clarification that discount code is for the software. But right now they're running 25% off on the books, which I actually, if you look in the miscellaneous PDF that we sent over, I took a picture of that. I would recommend right off the bat, you get this living trust, the one that we're going through now, but also the powers of attorneys books, as that's necessary for your living trust package. So right off the bat, get those 2 books. And those are 25% off now, and maybe it looks like Calda may be working on even getting a better discount, but then 50% off on their software. Their software is only $99. So you're talking about $50 to get your business off and running, and that's in a software format. And a lot of people prefer that. I actually do have that. I just don't use it as often because I was used to using NOLO this way and used to using the templates from the book. And, you know, you get stuck with something, you get old like me, and that's just what happens. So, but I recommend them highly. Everything NOLO has going on is very easy for us to use.
And I don't update my books every year, but like Jenny and I found out, there is a discrepancy between volume 14 and volume 15. And we'll talk about that in a little bit. She may have found a little oops in volume 15. So we'll see.
Right. And you do want to update it. You don't have to update them every single time one comes out, unless there's been a lot of changes in the law. Right. Like we have had the amounts keep going up every year, the threshold amounts for probate and things like that. So it's not very much money. It's like $30 to $50 once a year. I mean,
you need the write-off.
Yeah, exactly. It's a business expense. So some people are just commenting on a couple of things. I'm not going to restate those things. The state has probate with no exemption once the threshold is met for probate. Whereas the state is considered, that's correct, Colleen. Never done a trust, but I'm going to practice with mine. Great, Julia. You'll do great. And Daylin, if you become a fiduciary, let people know. Anybody who decides to do that, it's definitely something I need a little bit of education stuff before. My attorney's already asked me to look into it, so I'm getting involved in that and thinking about whether I want to invest the time in that. But if any of us LDAs actually look into that and become a professional fiduciary, please spread the word. We would all use you, you know, and the courts need professional fiduciaries to refer to. It's a great avenue for our businesses. And you do not have to be an attorney, and you do not have to be an accountant. You just have to have certain educational requirements. And then again, you want to have a strong, you know, nobody wants you to handle their money if you file bankruptcy several times or have a low credit score and stuff. So think about those things as well. So Okay, well, we are about done with questions and we are pretty much at lunchtime here. So we'll just end up a little bit early. We're going to take a half hour for lunch. We're going to come back at 12:30 and then we are going to launch into the documents themselves and go through those. So make sure you've got both your sample if you want to do it yourself and the Word document, or the PDF is what we're going to have up on the screen and just kind of go through building through. And I'm going to show you my entire packet. So there's going to be some things in there that even might be additional, and we'll talk about that further. So okay, everybody enjoy your lunch. All right, everybody, we're back.
Okay,
good break.
We're back. We're going to talk about property without document title. How do you transfer that property? Well, if you don't have a document title, you don't transfer it, but you can put it in your assignment of property so that it's noted somewhere. In almost all states, you don't need to do anything but prepare your trust documents and list the property in the trust schedule. That's pretty simple. But we were just saying, if you have an expensive piece of art or whatever listed on there specifically, that your Van Gogh is part of your property, not who it's going to in that assignment, but that it's listed so somebody will go looking for it. Property with title, you need to transfer that property. We just went over the grant deed, talking about that's the simplest one. Some types of property without title documents may seem to require formal transfer because they are owned in paper form, such as promissory notes or deeds of trust. You can use an assignment form to make absolute clear that this property would be transferred to the trust. And then finally, trademarks, patents, copyrights have special transfer forms and can be discussed, but you need to be able to list them at least so your heirs know you had something like that. Property you acquire later. There's a big back and forth on this. If you acquire property, you can only acquire it in your name, and you do a grant deed taking it as Jane Doe, and then you do another grant deed that says Jane Doe, trustee of the Jane Doe Trust. Well, according to NOLO, there's no reason to buy the property in your personal name and then transfer it to the trustee. You can buy it as trustee of your trust. So you're welcome to do that. An interesting question popped up, problems with financial institutions. And I've seen this a lot, where people are told you can't do that, only our trust department can do that, or you need a federal tax ID number. If this happens to you, simply insist that the absolute legal and essential for you to re-register your property in the trustee's name, and that it can be done without a new taxpayer ID. And I've seen that a lot with banks, where all of a sudden they're doing new certifications of trust. Don't know why, but it's up to them, and it's their trust department that's doing it. If you want to play devil's advocate, you can request to speak somebody higher up in the bank. It's up to you. The certification of trust is to establish that the trust exists, who the trustees are, their tax ID number, which is most of the time one of their social security numbers, the address of the trustees, and then the information about it. It's pretty simple. Using that, people like to know that they don't have to disclose their whole trust. Some banks require that you bring your whole trust and they copy it. I guess you could dig your feet in a little bit and say, no, here it is, and you would be correct. We've gone over the certification of trust. Real estate gets transferred in with simple grant deeds. Mobile or manufactured homes are transferred differently. Timeshares are different. All organizations have their own forms, but list the property at least. Well, not only your assignment, but find out what the forms are and then make sure your client completes them. I record the deeds for my clients so I know what happens. Out of state real estate. I have many clients that own property in other states. It can be a real hassle. If it becomes one, hire an attorney in that state and deal with it. but at least list the property on the assignment and in the schedule. If it's joint, put it in Schedule A. If it's one or the other, if it's the wife's, it's Schedule B. If it's the husband's, Schedule C. And let's see. Real estate outside the United States. And where I live, we have a large Hispanic population, and many of them own property in Mexico. There is no reason to transfer foreign real estate to a U.S. living trust. That property won't go through the United States probate anyway, and U.S. courts don't have authority to order transfer of real property in another country. Each country has its own rules and laws, and that's it. However, I do on the list of assignment list at least the state in Mexico where the property is, the address if you can get it from them, but they want that property to go to somebody else. It's not going to go through probate, and you're going to have to deal with it outside. But transferring foreign real estate, if you own that property, consider hiring someone in another country to learn what you need to do. After all, if you own real estate in a foreign country, that's fortunate. So spending a little money to learn how to transfer that property after your death is a small price to pay. And it really does make a difference. Stocks, government bonds, vehicles, we've talked about that. And then we haven't talked about how to transfer small business interests to your living trust. Most of us, I imagine, are sole proprietors. I'll read this to you. Because you own the business asset in your own name as a sole proprietor, you transfer that to your living trust like you would any other valuable property. For many businesses, this simply means listing the business asset on the appropriate trust schedule. For example, all property and assets used in the grantor's business is going in there. Because there's no ownership document, there is nothing further required. You own the business, but you can't transfer it. It's just there. I cannot transfer my business to my husband. He is not an LDA, but he can handle the assets and take care of it as my successor trustee. So you can talk about solely owned corporations, closely held corporations, or limited liability corporations. I have forms that I received from Jeannie Bruin when I had a client who had 3 companies, and I didn't know what to do with them or how to put them in there. But there's paperwork to transfer the LLC that's very simple. If anybody's interested, we can go into that some other time. Partnership interests. You can transfer your partnership interest to your living trust, but you must notify your business partners and modify the partnership agreement to show that your partnership interest is now owned by the trustee of your trust. And if there are partnership certificates, it must change to substitute the trustee as the owner. So again, you want to talk to people when you're doing this. Copyrights, patents, and royalties, they all have their own unique transfer situations. So there are a lot there, but in chapter 10 of the NOLO book, you get your answers. All right, so now,
let's go ahead and finish up a few questions that came through just before we went on break. So we'll go through those real quickly. Then we're going to talk about storing, recording your trust, and also talk about amendments and some of those things. So when trustees divide trust as trust 1, trust 2, no need to record the deed to county clerk, how to name trust 1 and 2. We kind of spoke about that. No, you do not need to record anything with the trust. And that is, you do not really need any paperwork. You can name the trust 1, trust 2. You can put a name on it if that makes it easier to understand. That's meant for the trustee to basically divide the property. They can do worksheets on that to show that property being dispersed. If everything's being left for the surviving spouse, it's really a moot point. And so don't put too much stress on that if it's being left for the surviving spouse first. Does the client need to record the certificate of trust with the clerk's recorder? No, it is not a requirement in California to record the trust or the certificate of trust. However, if there is, if for some reason it did need to be recorded or the client really, really wanted to record it, have them record the certificate of trust. That just at least shows that there's a trust established and you know, the trustees that are available for that, but it's not showing all your property and who you're leaving things to. So, but there's no need to actually do that. There's no law stating we have to for any reason. Paragraph on the trustees' payments. Either there's no payments to the trustee or listed under the child's trust. It does have the paragraph regarding giving the trustee a reasonable fee if necessary. So that's in that portion of the template, and that's on NOLO's template themselves. People ask me, this is a question, why do I need a will if I'm getting a trust? Dalen says he usually tells them it's the purpose of a reportable will is any property that was not originally included in the trust or couldn't be placed in the trust. Yes, that is true. Really, to me, it's meant as a backup. I tell people you should hopefully never, ever have to use this will, but it is meant as a backup and it makes a complete probate package. Also, again, shows their intent. So if something did get left out and had to be transferred to the trust, you could do the Hegstead petition, or you could do a simple probate and they could transfer it back into the trust. So yes, include that because that makes a whole complete package. And I usually, like I said, tell my clients should hopefully never need to use the will, but it's there in case you do. At what point does the trust get recorded with the county recorder? Really at no point, maybe upon someone's passing. Now you do affidavits when there's a change of successor trustee or a change of one of the original trustees. And on those affidavits, some of the samples say to attach copies of the portions of the trust that show the successor trustee. Some of them say that, but it is not the law. You do not have to do that. But there are templates out there that will say to attach the copies of the trust, but just know that that's not necessary. However, if there's a death of a trustee, then you will be attaching a death certificate, an original death certificate, which of course will get recorded and you'll get that back to you, or the client will get that back in the mail. Catherine's asking if you get the templates from the books, and yes, everything that I have shown except for the HIPAA has been a template from the NOLO books. Where did you get the grant deed document? That is Sac Law Library, which I think somebody put their info in the chat. They are amazing, not only just for grant deeds, for like a million things. They're amazing. They show you step by step how to fill out all kinds of legal forms. Can you repeat what is in your blue stamp?
It's the verbiage about,
the verbiage on that grant deed was already pre-printed there from Sac Law Library, but that's where Carol has her blue stamp that says all that that code, and that avoids that $75 fraud fee or whatever it's called these days. So now, always remember, if it's their primary residence, they do not get charged that $75 fee. But if they've got a second property, they will be charged that $75 fee. That's not waived. So make sure you're taking that into consideration. Just like Carol, I record the grant deeds for people. I don't trust them. I think that's one part of our service that is different from most attorneys. Even my estate planning attorney that I work with, she used to not record the deed. She'd give them instructions and send them off with that, and found out that that wasn't getting done. And so now she does it herself as well. So I just think it's a really great service, and we all know that that's the basis of this whole trust, is getting their real property put into the trust properly. So in my mind, I'm doing my client a disservice because they don't understand it like we do. So, but just remember that when you're figuring out the fees, if it's not their primary place of residence, the $75 fee does.
plus the recording fee.
Plus the recording fees on top of that. Yes, thank you. The last page, what is it and where does it get filed? The P course sheet. Preliminary change of ownership. There is you can get a generic one somewhere. They're all the same, but every county has their own, and they'll put their little stamp in the upper right-hand corner. If you go to the county recorder's website, they usually have them on there, and they're usually fillable, so they're easy to go through and fill those out. But if you do not include them when you do a deed transfer, the that it could get reassessed improperly, and they can charge 20 or 25 bucks, yeah, for that. The assignment of property form is in the NOLO templates. Ginger was asking, can we set up the same trust even though husband and wife do not have separate property or debts? Yes, of course. You just would not put anything on those separate schedules. You put none at this time. Carol has suggested. Nancy. We talked about Carol so much. Oh my gosh. Nancy, thank you. I'm so sorry. We were talking about Carol and that stuck in my head. Thank you, Carla. Does NOLO software create a new certificate stating this? Does NOLO software create a new certificate stating this? I'm not sure exactly what you're referring to, Dolly. They do have their certificate or abstract of trust in their document. So if that's what you're talking about.
Let's tell them volume 15.
In volume 15, in the most recent one, I'm actually going to write to them because their certificate of trust is not in the uploaded documents. But they do talk about they do talk about it in their book. So I think it's just something that was forgotten, and I'm going to mention to them that template's not in there. Is it the duty of the LDA preparing the living trust to obtain the necessary documents from all entities, such as timeshare stocks to transfer into the trust? Such would we be doing with the grant deed for real property. I walk everybody through those things. Obviously, if they're younger, I expect them to be doing the legwork. We don't really have time, and I don't usually account to do lots of different, to go find different paperwork from everywhere. But what I will do is I follow up. I literally put them every 2 weeks to a month, depending on the person, and we'll follow up and say, so, hey, did you get the paperwork from Fidelity to get that transferred over as you wanted? And I will assist them in actually filling out those forms. It doesn't take us a lot of time. We're professionals with forms. And most of the time, you're not going to have those. Most people, it's the house, you know, but yeah, so that's a personal choice on what you want to charge the person for one thing, and make sure that time is accounted for. Or you can let them do it and just remind them. I really feel it's our duty just to kind of help make sure that everything gets funded, and I'll go through the list and keep reminding them if necessary. What's the difference with a will and a pour over will? Nothing really. They just call it a pour over will because it pours over into the trust. So there's nothing really different. And it's all still a backup, yeah. If you record a certification of trust, please remember to redact social. Thank you, Lori. Good points.
So again, why you don't record it?
Right. You really don't want to record. It is not necessary in California. It is necessary in some states. It's the law in some states, not California. But that is why there tends to be, people tend to get confused about that because they hear all the time that they have to record their trust, and not in California, which is kind of weird. We usually have to do everything in California, and this time we don't. Asking because I've always seen the portable will and living trust. What are the costs of recording a grant deed? That varies by county,
right. But
I usually tell people it's anywhere from, I usually tell them it's around $35. It can go anywhere from $20 to $50 depending on the county. And then of course, plus that $75 fee if it's not their primary residence. And I vaguely recall you said the trustees have to agree to be trustees. Well, yes, technically, yes. I mean, you can appoint anybody as a trustee, but if they're not willing to carry out the duties of that, they're just going to resign. So you don't want to, you don't want to have to be going back and redoing your will and doing amendments. So you should check with who you're going to appoint as a successor trustee and make sure that that's something that they're willing to do ahead of time. I recommend that to my clients. All right, so that's good for the code. See, I'm reading and talking at the same time and pulling up, calling people the wrong names. So let's talk a little bit about recording the trust, storing and recording the trust documents. As we just talked about, you do not need to record them with the county at any time. It's not in California. I create a binder for my clients, put the cover sheet in there. Like I told you, I have the 8 different tabs, one for each of the documents, and then a miscellaneous tab. And I put in the front, I put the originals, and I tell them you should never touch those. leave the originals in that front pocket, or you can even put it in the back pocket so it's not right in the face. The front pocket, I do give them copies, and usually I give them as many as they have with trustees, 2 or 3 copies. It just depends. But I do not necessarily tell them just to go give copies to all their trustees because, as we spoke about earlier, that may not always be the best thing to do, especially if the trustees are also the beneficiaries and they know exactly what they're going to be getting. Now, if you have separate trustees from your beneficiaries, you could give them a copy ahead of time, but you also don't want a bunch of copies out there, because what if you decide to do amendments later?
There you go.
What if you decide to revoke the trust entirely? Then that's a reason why you might then record your revocation with the county or something. If you have given out copies of your trust to your successor trustees, to your beneficiaries, and now you've decided to revoke the whole thing, or your client, excuse me, has decided to revoke the whole thing, you might want to record that revocation with the county. That might be appropriate at that time, because that just makes sure that it's on public record somewhere that that original trust was revoked. But those are problems and complications that will come up if you're giving copies to everyone. So basically, you know, more is less. Or less is more in that case. Don't give out copies unless it's absolutely necessary, or the clients are really specifying, and explain to them why. Sometimes though, if they have 2 kids, they're going to give them copies that they're close and that type of thing. So,
Can I tell them what I do?
Yes, please.
Okay, so she does a binder, she does tabs, she gives extra copies. It's great. You live in a metropolitan area. I live in a rural, so we're trying to do both ends of this, from the simple to the large. My clients do not like binders particularly. One, it looks like an attorney did it, so I'm concerned about that. I find envelopes, and I know you probably can't see this, but this color blue. And inside, I do the cover sheet with their name of their trust. At the bottom is all my information for whoever needs to come see me later. Inside is the declaration, the assignment, the certification of trust. I do the powers of attorney and make copies and stamp the word copy on the copies, and try to scare them into thinking that if they ever give away their powers of attorney, they're sunk, because they are. If they give the original away, we cannot come back and do it if they're not mentally capable of doing it. So I make copies and tell them they can make as many copies if they want of the powers of attorney, and give it to the people that they're asking to be their agents. And I do it in the blue see-through envelope because it fits in your safe deposit box, which many older people still think is what they should be doing. Or it fits in their gun safe and they can see it when they open it, because gun safe in my area is a big deal. So it's whatever fits for your locale, whatever is the custom and culture there. Some clients like the nice big binders and the tabs, and it makes them feel like something's done. Others are like mine. Whichever way you go, put it together in something that your client can use. And we're not going back to powers of attorney, are we? No. Okay, I want to talk about powers of attorney just for a minute. From personal experience, powers of attorney are the magic pill for so many things for older folks, and for you if you're the agent. So I make sure you have copies of that. Along with the powers of attorney, I suggest that they get a file folder and put in a copy of the power of attorney, especially for healthcare. I ask them for their ID, their driver's license, their medical card, if they're a veteran, their VA card, and their Medicare card. And I put them all on one page and copy it and clip that to the back of the power of attorney. And then a list of their medications. They all laugh when I ask that, because by then most people are taking more than one medication. And the name of their doctor, just on a list. This is Jane Doe's list of medications for Dr. Smith. And put that in there, all in a file folder. And what I have learned from personal experience, and also from now my clients, because I've been doing this so much, is I suggest they put it in some kind of briefcase or something that they know they will use, so that when something happens and it's an emergency in the middle of the night and you, the agent, cannot think, You can pick up that briefcase and go with them to the hospital, go where you need to go. And you have all the documentation you need to help the person you are an agent for. And the hospital personnel are amazed because for them, it's like pulling teeth to try and get information. And you've got it all there and you don't have to think. It's worked for 20 years for me. I really recommend that you do that with powers of attorney. Suggest it to your clients. Make sure that they think about that to do it for their agent, for the person that's going to be their agent. Make it a little easy for both. Okay.
Very good. So we will talk a little bit about maintaining the trust and doing amendments or revocation. As we talked about, they are able to add property to their living trust at any time, or sell or give away the trust property. Things to remember that, and this is an avenue of your business. You can put in reminders for once a year to touch base with your clients. It's a way to keep in touch with them. Longer, I'd imagine no more than a year, but you could even do longer than that if you wanted to calendar out far enough, and just touch base with them to find out if anything's changed. It's a way to create some extra money, do an amendment, and make sure that they put their property properly in the trust. Maybe have to do a new grant deed. But again, at any time, they can add property to their living trust. Another good time, if you are adding the property to the trust, some things you might need to do is type up a new schedule. You might need to remove the old property, what they sold from the schedule, take that off the schedule. Do they need to do a new title? Again, if they purchased property, they may need to do a new grant deed. What I have noticed a big difference in over, especially like even the last 10, 15 years, is that 10, 15 years ago, they would never put a property back in the name of a trust when you did a real estate transaction. Nowadays, they do. They do it more often than not. So if you let the title, if your clients let the title companies know that they have a living trust, they, most cases, they'll go ahead if they're doing a refi or if they're purchasing a new property, they'll put it in the name of the trust. And then the person is signing as common trustee for everything. But that's when you want to advise your clients to make some changes, or make an amendment. If there's been several changes, you definitely want to go through and make an amendment for them, change their schedules if necessary. I'm going to go ahead and pull up the example of the amendments. We can talk about that a little further too. All right, so here is a sample of an amendment for the trust. This is the first amendment. You always want to number your amendments. They can have many. So this being the first amendment to the revocable trust of John D. And I name this differently than the rest of it. John D. Smith and Mary J. Smith, dated October 3rd. This is from a completely different client, so it's done a little differently. But this is where we put their names as part of their trust. The amendment to the revocable trust of John D. Smith and Mary J. Smith, dated this day. That was their trust name, is made on the date that you're doing the amendment, by John and Mary as settlers of the trust, or grantors. Settler and grantor is the same thing. You always want to, and I believe this one was done it wasn't a NOLO, it was somebody else who brought it in off the street. So you want to look through their trust. It's somewhere in their trust, if it was done by another person, there is going to be a section regarding amendments and the power reserved to do that. And you want to list that, Article 2, paragraph 202, find that within the trust and list that in your amendment. And then you're just going through and making the changes that they requested. In this case, they had a daughter whose name changed, and she actually added a hyphenated name. She got married. So they wanted all references to her to be updated to her -doe name, and I put the pages that they were listed on because it wasn't a really big deal. We didn't need to go through and they really didn't even need to do this, but this is what they wanted to do. So we went ahead and just added it onto the certificate. People's names do change over time. Same with them moving. As you saw on the certificate of trust, it actually lists the address of the successor trustees. They may move from time to time. That's okay. It's an identifying marker just to make sure that when they're looking for that Jane Smith, that they're finding, is this the Jane Smith who used to live at 1234 Main Street, you know, so they can make sure that they're getting the right person and identifying that way. Or you can do updates if the clients want. It's more money in your pocket to do amendments, so go for it. Article, in this case, these are just samples. Everybody's is going to look a little bit different. Include the life insurance policy, which is an already existing policy and part of the pension benefits. So other ways to do it, the following is deleted and replaced from the trust. So Schedule A is deleted in its entirety, and a new Schedule A is hereby attached to the First Amendment. We also deleted Article 8, Section 804, Paragraph A. It was deleted in its entirety and replaced with this language here. Karen Smith Arnese shall receive the cash sum $50,000. The entire rest of the estate is going to be split between the three of them, or their lawful surviving issue by right of representation, in default of the survivors among them. In all other respects, the trust as executed originally by the settlers is affirmed. Down here is where I have that new Schedule A I have attached to that. This is notarized as well. Again, I didn't include the notary slips. You want to make sure these are all notarized, any amendments that you make. Let me see what NOLO also talks about when to amend. Of course, when you marry or have a child, those are all good reasons for why you want to amend your, amend your trust and do an amendment to it. Also, if you're changing beneficiaries, changing trustees, you want to do an amendment during those times as well. If you are changing a lot of property, you're going to want to do a new Schedule A, just as you saw in that example.
On mine, when I amend them, I write the word, the following is deleted, and I put verbatim what's being deleted, and then below that I write the following is added, so that there is clear definition between what's added and what's been deleted, so there's no question.
That's good. And there is and the NOLO package, the NOLO product does include it does include the templates for this. Yes. For an amendment for joint trust and an amendment for a single person trust. So that is in the templates when you purchase the book. Okay, that's regarding moving and changing your name, of course. So reinstatement, we had some questions about that.
And that's deleted and added.
Yeah,
good.
Yeah. So the template is very clear. So use the template from NOLO. It goes into delete this and say this. So it's a really good template. In regards to reinstating the trust, that can be done, and NOLO recommends you do that when there's lots of changes that are being made. Chapter 12 of the new book goes into that in detail. And you basically just are reinstating. They even give you the language to use to do the reinstatement. Let me find the exact wording that they're using. So in this example, they're saying, the Dennis Clifford Living Trust dated October 11, 2001, revised and restated January 3rd, 2020. The reasons that you would want to do trust reinstatements is if there is a lot of changes being made, but we don't want to go back and change title to all of the property that's been put in. If you actually revoke the trust and create a new trust, you are then going to have to go and change the title on any property that's been put in there. So any especially real property, their residence, any rentals they may have, any timeshares, anything else with title would have to be retitled. So in order to avoid all that and that extra expense and time, you just reinstate. But when there's and you really only need to do that if there's a lot of changes being done. Otherwise, just doing a first or a second amendment will suffice. And your amendments become part of the trust. I actually tell people to stack them right on top of their declaration of trust. So you see the amendments first, that people don't miss them, and then they can go to the meat and potatoes of the trust, but they're seeing those amendments on top right off the bat. They can also revoke the trust. I do have a sample of trust revocation as well. Some of the reasons why you would want to revoke a trust is if there's extensive revisions and you don't want to reinstate it for whatever reason, or maybe a lot of the property has already been sold out of the trust, so you don't need to do new titling. They could revoke the old trust in its entirety and create a new one. Divorce. That was the very next one. Is one of the most major reasons that to revoke a trust. And again, I think we mentioned that earlier. It's a great way to get more business. If you're doing a divorce for a couple and they bring that up, then you tell them, yes, I'll do a revocation as part of your divorce process. So you charge them for that. And then you guys come back to me. Here's the paperwork, your questionnaires to get started on doing 2 separate new trusts for you guys as well. Those are the biggest reasons why you'd want to revoke the trust. Again, I would record it. If you've got copies of a trust out there all over the place, I would go ahead and record the revocation of the living trust. As you can see, it doesn't have a lot of sensitive information in it. This is also notarized. The revocations are notarized. Everything is notarized except for a will. I mean, every single one of these documents. If you're not sure or you can't get clarification, notarize it. It will never hurt to notarize documents. So in almost every situation, right. Yeah. All right. How are we looking on that time?
Very good.
Yeah, 2:36. Yeah. So we have, we've gone through, let's see if there's any questions specifically on, I'm going to stop sharing this for a moment. George, we've got some comments here. So let me just do those real quick and then we'll get started after the grantor dies and the last few things to talk about here. We charge for funding following delivery if they can't get it done on their own. So Colleen's got some good comments in here about charging. And I do agree that there has to be an end. You know, if you don't have people who are helping themselves, you can't spend all of your time looking for different forms and stuff. So it is great to have either, you know, I'll help you 1 extra hour or have some limitations on that. And Colleen has some great suggestions in the chat if you want to look at that. Okay, and then everybody's happy with their new code, so I'm glad everything's working. Thank you, Catherine, for getting that going. I'm going to look in the question and answers now. That was in the chat. Can we transfer from the old trust to the new trust directly? Yes, you can. You can transfer the old, if it was in an old trust. One thing you need to be careful, make sure you have a sample of a trust, a deed where somebody has it in the name of the trust and is transferring it, because you need to make sure under their signature when they sign that it states that they're trustee, and you have to completely spell out the name of the trust. I've even seen it put above the line of before they sign and state the trust, the name of the trust. It has to be in there. I've had a deed kickback on that just said comma trustee. That wasn't good enough. We had to put comma trustee of the Smith Family Living Trust dated da 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 da. So get a nice template, but yes, you can absolutely go from one trust to the other. Make sure you do the P-Corp sheet, put on there, check mark that box that it's going from one trust to the other. Trustees do not sign the living trust to accept that they will serve. No, the trustees do not sign that they're accepting them to serve. It's not required here in California. I have seen some templates, especially on powers of attorneys, where they will sign, but it's not necessary. Yeah, as the agent, yes. Yes, so yes, that's true. And that's on a power of attorney. So no, the trustees don't need to sign anything. And if they are appointed and they don't know about it and they don't want to do it, they can resign. How do you work with families who only speak another language? Do you include a copy of the translated document? I send them to another LDA who can speak their language. I am too busy to get all my documents in different languages and stuff. And I want to make sure they're dealing with someone who understands, you know, you're using a lot of legal words and trying to explain a lot of stuff to people. I don't want there to be any misinterpretation, especially in my documents. And I want them to be able to speak to someone who understands and maybe even understands a culture better than I might. So always I'm going to get them in touch with someone who can who can speak their language say if we're not clear, or they need that additional help. Now, and I don't even really feel comfortable in something like this. If it's something small, someone just wanted to come in and get a grant deed and had their grown kid with them or something as their interpreter, that's one thing. Usually that's okay. But if I was going to do an entire trust, especially if it was complicated, I'd send them to someone who can speak their language. Because how do you know? How do you really know that they're understanding what you're saying when they're saying yes, yes, you know, and answering you? There's just no way to know for sure. What would be the easiest way of, instead of amending and redoing schedules A, B, and C for someone that is constantly buying and selling 10 pieces of real property every year? They're lucky, and they just need to pay to have the states updated regularly. Honestly, they are obviously making some money.
Yeah, if it's just the schedules you're amending, we've already covered that. Just add it to your schedule.
Yeah, I mean, property, you're going to have to do a title change. Right. So at the same time, update the schedule. I mean, they've got to be going to someone to get the grant deed done, unless they're just putting it back into their name of the trust when they're doing their sales. Then the person can reach out to you and say, hey, every 6 months, hey, update my schedules or whatnot. But when it comes to real property, that's something that I'd want to put in an updated schedule. I mean, it's not the same as just line iteming out, although you could give them extra pieces, extra schedules, and have them just line out, this property was sold on this date, and then initial it, and then add on the new property. You could send it to them in a Word format where they could type it in and do it themselves. So they're constantly keeping that fresh, or you can get the business from them themselves. But there's not really any easier way, and I really want to list your real property. I mean, that's the most important thing. Right. So I'd want to put it on the schedules, even if it was a pain in the butt. A restatement does not require retitling of the trust property. Did I misunderstand what you said? No, that is the purpose for a reinstatement, Colleen, is that you don't have to retitle, because you're keeping it the same name of the trust. You're just reinstating it as of the new date. And reinstating and any changes that you're making, and then you're doing a reinstatement of all other trusts. Everything else in the trust stays the same. Again, if you read the chapter on NOLO, they kind of delve into it a little bit more and give you the specific language to state for the reinstatement. But that is the whole purpose of it. So then you don't have to retitle property. You can, and you don't need to do a reinstatement unless they're doing a lot of changes or have done a lot of changes. Sometimes people start getting up into 3, 4, 5 amendments. Okay, maybe at that point you might want to do a reinstatement and make sure. Is it true that a holographic will should not be notarized? No, a will should always be witnessed. A holographic will, okay, but so technically a will is someone could write it on a napkin and a will can be valid. So we all know that. So if somebody went and did a will on their own and wrote it out and had it notarized, okay, we're going to submit that to probate on their behalf, regardless. But a holographic will is going to require that form off the top of my head. You've got to have 2 people prove it up, and that's that person's handwriting. So whether it's notarized or not, you're still going to have to go through the same procedure. But I mean, if it's notarized, if the person went and did that on their own, I would not advise people to go do that. That's not, will should be witnessed, not notarized. But if they went and did it on their own, okay, submit the notarization form with the will when you open probate if you had to. So. But if it's handwritten, it's going to have to be proved up with the extra forms and extra steps. You consider supplying your fee schedule. Yes, you guys should talk about the different fees. The fees really matter via area and how much time you want to put in with those people and things like that too.
How about, Carlo, if we put out a survey, and we'll just put out a fees survey, anonymous, and send it in, and let's see in the next month or so what we get. We could do that.
Sounds good.
All right.
When you translate the final documents, I think we kind of covered that. If the client is only Spanish speaking, does the living trust need to be in Spanish, or does it still need to be in English? If the client is only Spanish speaking, I would assume you want a Spanish I mean, I guess you would need both, because I don't know with the trustee. What is the trustee? Trustee has to know how to read their powers. So that's getting a little tricky. And I guess you would need to have the English version. If you submitted it to the probate court, you would have to translate it into English version. The probate court requires any will or trust document that was written in a foreign language be translated, and you have to submit a copy. You have to submit the translation along with the original will. So I would assume that would be the same thing. As you can tell, I don't do trusts for people who do not speak English, because I'm not going to take that liability on. You might want to, that is something that could be clarified with an estate planning attorney. But I would expect that you need to have both. You need to have it in Spanish for them to sign, and then have it in English version, and I don't know, maybe have them sign again. So I would verify that. That's kind of getting into legalese. So I would verify that with an estate planning attorney, or send them to an estate planning attorney that speaks their language. Right. Yeah. Would you suggest restating, updating the trust if the original was done in 1999, 2001? Only if there's been changes, Lisa. If it's the same, and if the beneficiaries are all still living, that's another reason why you might want to do amendments. If the beneficiary has died, if a trustee has died. So when you get into the older trusts like that, that's why it's good to do a review every so often, and make sure that all your beneficiaries and trustees are still living. Otherwise, no, you really don't need to. I've seen people have really old trusts. I've seen them from the 80s, right, the 90s, and they're just as valid. So, and then Dalen's Constitution requires English as the official language on all court documents. So yeah, all court documents need to be English. Thank you. It's kind of the way I figured, but I don't ever get into it, so I don't want to walk someone the wrong way. All right, so let's talk a little bit about after the grantor dies.
Okay. So, thank you. So after one of the parties passes away, usually the remaining spouse will come in and sadly tell you they've passed away, and you offer condolence and ask if they have a death certificate. And hopefully you still have a copy of the grant deed or the new grant deed in your computer, so you don't need them to go get one. But if so, you need that. You prepare an affidavit of death of trustee and make sure that the county knows that the property is still in the trust, and you record that, and that puts it in the surviving trustee's name, and that's it once you do all that. Once they're both gone, then the trustee, the successor trustee, comes in and goes, what do I do now? And there is like a checklist in the NOLO book. If the trustee resigns, says, I've got an illness now, when I agreed to do this, I was fine, now I can't. You go to the successor trustee. If there isn't one, then you sit down and talk with them about who do they think would take care of this. And usually they've got somebody in mind, a relative, someone that knew the couple, somebody. But then you just get them to resign officially on paper. And then the ex-trustee should prepare a notice, sign the notice in front of a notary, and then deliver the notice to the person next in line. So whoever it's going to be, and it's very simple. And there's a sample in the NOLO book. And then the new trustee is appointed. And normally it would be the last or the alternate, but the appointment, again, must be done in writing, signed and notarized, and the trustee making the appointment can prepare that. And again, there's a template. In chapter 13 of the NOLO book, it says trust administration after the death of the grantor. And there are 10 bullet points on what you need to do. And it talks about obtaining several death certificates, preparing and record documents to establish the authority of the current trustee if you need to, how to transfer the property, notifying beneficiaries. That's another big one. Having done that myself, I sent copies of the trust and the notice and a cover letter. And in that trust, there was a disinheriting of one of the nephews. And all the other nephews got a copy of that trust, finding out that their cousin had been disinherited. That created an interesting situation. So again, that goes with perhaps you don't want to do that. For all securities and stock accounts owned by the grantor, acquire a statement from each financial institution holding the account for the value of the account as of the date of death. Then if the deceased grantor had a retirement account, you check with them, with the bank, or usually it says, you check with the retirement account. So it's listed somewhere, or there's a statement somewhere in all of their paperwork. You file federal and state income tax returns, but deal with somebody that's used to doing that. And then notify Social Security. And what I remind people is, depending on the date they passed away, Social Security may pull back that fund in the account. Don't rush in there and close an account. There are all kinds of little tricky things there. If the deceased person had remarried or had anything else, that person may need to do now a new will, a new trust, all kinds of things. These take some time. Also, if there was a bank account with only that person's name on it, again, you can do the affidavit for collection of personal property, but it states on there that the grantor, it's been 40 days since the grantor passed away. There is no probate, and these are the people that should get the funds. So again, banks, it's pretty easy if you work with a bank, so get familiar with your banks. If the trustee wants expert help, I remind the clients, that may mean the tax preparer. It may need an attorney for something convoluted. If there's property outside the state, you may need some help with that. And then this was interesting, appraising the value of significant trust assets. Usually in my business, that is not necessary because it's passing to family members. It all goes to them. And then if they decide they want to do something with it, that's up to them. But usually it's passing without any having to have any appraisal done. Providing basic information to trust beneficiaries. This gets a little sticky because one child is sure that they're not being told everything, and the other child doesn't want to tell the other child what's happened. And that can be a matter that may end up in court. And the judge will make the decision on that. Again, the checklist is wonderful in here. For an individual trust, it's very simple. For a joint trust, it's pretty much simple. It's when everybody's gone. You transfer the property. As the successor trustee, you're going to transfer that home on 123 Main Street to Billy and Johnny. And you come in and have the grant deed prepared as the successor trustee, and you give it to them as they want. And your job is to find out how they want to take title. Maybe one of them wants it, one of it doesn't. They'll work that out. But your job is to give it to the two of them because that's what the trust said to do. You don't get to change that. And then once it's in both names, they can then determine if one of them is going to buy the other one out. You want to be careful that you follow just the trust and don't do anything differently. Cash, bank accounts, again, you're the trustee, so you take that to the bank and talk to them about that. Property without title documents, again, the jewelry, the art, whatever it's saved in the trust is what you need to do. If it's stocks and bonds or brokerage accounts, government securities, you're going to have to follow what they want, but you're going to need certified copies of the death certificate for almost all of these. So make sure you get enough. Tax returns. And we touched briefly on a child's trust, but if there is a child's trust and you happen to be named the guardian or trustee of that trust, there's a whole separate thing you need to do with that. And in chapter 8 of the NOLO book, they go over exactly what you, the trustee for that trust, need to do and how you administer that trust and what you need to do to finish it up when it's done. It's a lot of paperwork. It's not hard, but it's a lot of paperwork, and there's a lot to do if you're the trustee. Okay, that's a highlight.
And that kind of gets more into trust distribution. A lot of people don't even do that. They'll prepare the trust, but don't help with the distribution, as far as LDAs go. So that might be where you can refer the clients to go get NOLO's book, because it does really get into what to do with the business and how to get that transferred over. Goes into detail on all of that and setting up the child's trusts and things of that nature as well. So,
and I give copies. I copy things out of the trust book so they've got something in their hand, and it's not me giving the advice. Here is the paperwork.
But you're always there if they have
Right.
paperwork questions or need help. So it is lucrative, as Nancy says. She's done it a few times. I've really only done it once for an actual client, more for my own family. So, but it really teaches you kind of the ins and outs. Once you have to go through and do a distribution on a trust and make sure you get all the notices out to the beneficiaries and stuff, you really become familiar with all of the workings, and can better serve your clients, because you'll think of all these crazy circumstances that could come up that you want them to at least think about. So,
and you may end up having to sell the property if you're the successor trustee, and then you need to sign all that paperwork, work with the realtor, and bearing in mind you're not getting paid for this. So you get all that done, and then you have to open an account for the trust, the estate, because that's where the check's going to go from the sale of the house. They will not send it over in someone's name. It's got to go to the estate in the checking account. And then you can write the checks out of that to the beneficiaries.
Yes. So I've had some clients specifically state that in their instructions, that the house is to be sold and divided between the surviving children. So at that point, that falls on the trustee. So that's going to end up falling on the trustee. If it's unclear, if it just states that the children are getting the house, then the trustee can sign the house over to the children, to the heirs, and then the heirs can decide what they're going to do about it and kind of leave it in their hands. So
Right.
It does depend on all of that. We're right about 3 o'clock. We've covered mostly everything. I can show, I did have that one miscellaneous forms. Let me get those put up here.
Oh, there.
Yeah, they can't see it though. Oh, let me grab this. I'll share that last little bit of miscellaneous documents. So I put this in the miscellaneous section of the trust binder that I give people. The 10 steps to administering a trust. I kind of like how NOLO has it laid out. This was something I just grabbed off the internet, but giving notice. It's the very first thing. They're required by law to give notice. There's a specific form. I'm going to show you that here in a second. You must do it within, or the notice tells them that they have 120 days to contest the trust. After that, the trustee is free to start handling everything. They also tell you it's advisable to notice the creditors, identify trust assets.
Yes. Can we stop right there
Yes.
too? And I know this is part of probate, but as the administrator, if they were on Medi-Cal, you need to notify them, and they've got 4 months to send you a bill if they're going to. So you cannot disperse all the proceeds from this trust until all the bills are paid. Yeah. And so I know she's probably coming to that, but Medi-Cal is a whole different kettle of fish. And so you need to be aware, if you're going to deal with them, what their requirements are.
Yeah, we didn't even really touch on that.
No.
Identify the trust assets. That's where the trustees start gathering up all the trust assets, finding out trustees responsible for ensuring they're not stolen, lost, or destroyed. This is investing trust assets. For what we usually do for clients, there's not a lot of investment involved. Usually you're going to be just dispersing all the property and the trust is going to end, but talks a little bit about that, obtaining titles, obtaining appraisals if necessary, paying the debts, filing tax returns, preparing any type of trust accounting, Again, our templates, NOLO templates, provide that they don't have to do any formal accounting. I always recommend it to trustees, though, you know, do a spreadsheet, have some type of way that you can show the beneficiaries what's coming in and out. Somebody's going to ask, and you're going to have to be able to back that up, or else it could cause everything to go back to court as well. Prepare your distribution plan.
That's a really good one.
The distribution plan?
Yeah. Because then you can show that Jim's getting 10% and John's getting 18%, and they need to see that. They may not read it in the trust that way, but if you're showing this as an accountability, it's a lot easier to swallow.
Yes. And then distribute the trust assets. Here is a sample. This form is a little bit choppy, so it could be made a little bit nicer, but this is the probate code section, so you might be able to find a better sample. But notification by the trustee under the probate code section. So they're going to fill this out. They're going to attach a copy of the trust and mail these to all the beneficiaries. This is that very, very important language that has to be on there, that they have to bring in action or contest the trust within 120 days. After that, the trustee is free to move on. Here is the information from the DMV. Completing a transfer without probate checklist. This just tells them what to do, get the title, do this and that. There's a form, there's the form that goes with it. So I put that in there as well. And then here are the couple books that I was suggesting. Make Your Own Living Trust. That's what we've been dealing with today. And that's what all the templates are coming from. Like I said, they're having 25% off right now. So you're talking about $30 to have it downloaded. And then the Living Wills and Powers of Attorney for California. Those have all of your medical directives and have the powers of attorneys. Get that as well. So as you can see, for, you know, again, $50, you've got a complete package. Same with, now you've got that code if you wanted to actually get the will maker, which is more like a software where you're answering the questions and putting in the information. Try that too. We've got that 50% off coupons, which that gets that to about $50 as well. So
it's not a bad deal.
It's a great deal and fun to just, you know, get it and try it and see, you know, which one works for you, which ones, everybody's a little bit different. So, all right, well, we've got 30 minutes left. So let's look at some questions. We finished up a little bit early. We'll answer questions till there are none, and we'll go from there, and you guys are free to go. California code. So let's go back here. English is the official language. You guys all looked into that. Thank you very much. Pretty much was leaning that way, but I appreciate when we start Googling that stuff. What was the affidavit of personal property for a bank if the person is not listed on the account?
Okay, so usually it's a spouse, 99% of the time. And depending on the custom and culture of your client, it's usually the male that has the account. So the wife can come in and ask for that. The bank will send her down to me and we'll do one. She can collect the whole thing because she is the one petitioning. It could be she could put her name on there and then divide some up with her children. The interesting thing is they don't know how much is in that account because the bank cannot tell them how much is in the account. So until she files that affidavit for collection of personal property, she doesn't know what she's asking for. So the bank will help her as much as they can, but they have to stop short. So usually I ask them to go look for a bank statement somewhere in all of his personal papers. Somewhere there's going to be a statement from US Bank, Bank of America, Wells Fargo, whatever it is, and then bring that in. That gives me the account number at least, so I can put that on there. So the bank then says, okay, she has the account, we can do that. And they will issue a check in the amount of whatever's in the account. Again, don't know how much is in there because they can't tell you. I've had it where parents are gone and one child comes in and they want it all. And I just calmly, quietly, by the way, do you have any siblings? Well, yes, I have 4 siblings. And I went, what are their names? Well, why do you need to know? Because you're all entitled to this. And they don't like that. And they can go down the street. But the only way they can go down the street is to find an attorney who will charge them to tell them that. So usually it ends up very well, and then checks are issued to those people in those amounts equally distributed.
Can the NOLO software be used more than one time? Yes, I believe so. They're talking about the actual,
The software.
yeah, software itself. Yes, as far as I can remember.
Absolutely. You just wipe out the previous one and put in the new one.
Carlos is asking a question. Hang on, Carlos. Let me just see what's in the questions and answers before we start that. Where can you find a professional binder? Do you use a company or a binder? No, actually, I use just, I use 1/2-inch ring binders that I order from Office Depot. I do not make them fancy. I'm not an attorney. I mean, the fact that I'm putting it all in a binder to me is enough. So I get the kind that has the slip in the front, and that's where I put that cover page. So when they look at the binder, it looks like it's made for them, but it's just a piece of paper that I can pull out, put another name in. And then I get those dividers, the 8 dividers. And they're very colorful. Doesn't look like anything an attorney would provide because they all come in like one's green, one's purple, one's yellow. So, it doesn't look as legal, but there are places, if you really wanted to do professional binders, they're out there. You can order them, just Google it. Google Will and Trust Binders. That's who the attorneys go through, but it's a lot of expense.
It is.
And I have to tell you how many people have just come into me and have redone their stuff or have revoked their trust and just leave this huge binder of beautiful paper, heavyweight paper, and gold embossed binders and things like that. I mean, it's really a bunch of pomp and circumstance. That's not necessary. So don't put all your money into that. I think the binder makes people feel good. I also think it's a great place, or use the folders. I mean, either way, but give your customers some way that they can keep all their documents together. I tell people, like I said, when there's a life insurance policy, make a copy, stick it in the binder. When you pass, let your trustee have one place to go to. The pill medications, that was a great suggestion. I had to bring that up to my mom the other day. I'm like, Mom, I need you to write down all your prescriptions and when you take them. If something was to happen to her and she was incapacitated, I have no idea what that woman's taking, So these are things to think about. I've had to come and think about within my own family and how do we rectify those things. So that's a great thing to put in the binder. So get something so your clients have somewhere to put everything, but you don't need to spend a lot of money. And if you want to, just Google it. They're out there. There's companies that still do that all the time. What are the names of the books we're talking about? Again, everything's through NOLO. This is all about NOLO. Their stuff is amazing. They've got the trust books and they've got the trust software. They've got power of attorneys. So go to the NOLO website, NOLO.com, NOLO.com. When both grantors have died and successor trustee needs to transfer real property to someone, a simple grant deed can get it done by the successor trustee signing the deed as successor trustee of ABC Trust. What is the wording on the deed at section grantor XXX hereby grants to grantee? So it's going to be the name of the successor trustee, William Penn, successor trustee of the John or of the Smith Family Living Trust, dated November 20th, 2020. And then, of course, hereby grants to, and then whoever the grantees are and however they want to be vested. So if it's Jill Smith as her married woman as her sole and separate property, and probably in most of those cases, you're going to actually do like percentages. So 50% share to Jill Smith as her sole and separate property, 50% share to Jane Smith as an unmarried
50%.
woman, and yeah, it's just, and then
sign it and notarize it.
Yeah, sign it and notarize it. So the successor trustee is going to be, and then of course, down at the bottom, you're going to put the successor trustee's name, successor trustee of the blah, 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 blah trust. You're basically restating kind of the first line that you put in there, but that's how you would fill it out. Just like it was almost just like it was the original grantors. Upon the death of the last survivor, does the property first get deeded to the successor trustee and then again to the beneficiaries? No. Nope, it stays in the name of the trust until the trustee is ready to transfer it one way or the other, whether by selling it, whether by transferring it into the beneficiary's names, whatever's necessary. It just stays in the trust. Do you have a contract for the client to sign? I just use our call to contract. You should all know that. This is important. I would like to know more on Medi-Cal. The reason a lot of my clients do is a trust that they don't lose the house to Medi-Cal.
Correct.
Yeah, and they have actually changed the laws on that. So
you can have a house and a vehicle.
You can have a house and a vehicle, and if the house is in the trust, it could avoid it 100%. So we can get some more information on that. Also, Google it. Seriously, there's so much information out on it now. Talk to your estate planning attorney that you partner with. But from my understanding, if their house is in the trust, it's exempt. It's exempt now, so it may not come up. But if there's things from the past, or if it wasn't put in properly, or something was done improperly, there could be a Medi-Cal issue. So,
and there used to be a look back period
of a number of years. The look back period,
but that may not be now. So she's absolutely right. Google it. Get the most current information on that. The other thing is, if there was an adult child living in that house with the parent, and the parent now has passed away, and that adult child is living there and they had some kind of issue, you don't have a bill from Medi-Cal. So there are a lot of things you need to look at. Unless you're going to hold yourself out as an expert, get the information, but then have them talk to somebody else about what you can avoid with these things.
Yeah, so Julia, if people are coming to you and they're specifically telling you, I want to avoid having to pay back Medi-Cal, then you want to become an expert on this. I actually don't get that very often. Most of my clients don't have Medi-Cal, and that can be something you ask as part of your questionnaire. Have either of the grantors ever been on Medi-Cal or received Medi-Cal? Again, my understanding is that look back period is what was changed, so that
let's hope so.
Yeah, that's my understanding, but I have not studied up on it. So it'd be better to talk with an attorney or go look online. There is a trust beneficiary for a minor child. What about for an elderly parent? Can an elderly parent beneficiary have a separate trust upon the grantor's death?
Wow.
That's a good question. Because yes, so
special needs.
Yeah, I'm trying to think of how that. If so, the elderly parent, if they're not able to manage their own finances, they're already in a conservatorship, or there's a trust that's already been established for them. So then their share would be transferred to either of those, and their estate, you would have to include it in the assets of the conservatorship, if that's what they were under, or it would transfer to their trust if they had a trust properly set up. Usually, when is it going to transfer to an elderly parent? I guess maybe if they have a brother or sister that transfer something to them or something like that. Most children aren't leaving things to their parents, so it doesn't usually transfer up, usually transfers down.
Get to know a good elder law attorney.
Yeah.
Because the laws are changing, and with the elderly especially. I have one in Chico, and they have a phenomenal reputation. So it might be good to start looking for one of those as well. Yeah. Even just to answer your question.
Yeah, because that's an unusual circumstance and question that you're having. But I would assume in most cases, if they can't take care of themselves, they're already have a trust set up and somebody's providing, or they're in a conservatorship. So if you are both the executor and beneficiary, then you don't let anyone know.
There's nobody else? Then no. Who do you notify? Yourself.
Yeah. No, you just transfer everything to yourself. Yeah. If you're so, yeah, just do it all yourself. You don't have to let anybody know. Can the NOLO software be used more than one time? Yes. What name does the successor trustee use to open the account for the trust? It's in the name of the trust. The account will be opened in the name of the trust. So the Smith Family Living Trust stated.
What name does the successor trustee use to open the account for the trust? So the
The
successor trustee isn't opening an account for the trust.
Well,
Why would they come into play
if they're transferring assets into a,
after both of them are gone?
after both of them are gone, yes.
Okay, then it's an account for the estate.
Yes.
Does that make sense?
Yes. But is it in the name of the actual
It's the
living
estate
trust?
of Mary and John Smith.
Okay. But when the child's trust, it specifically lays out that it's the name of the trust with dash
with the
child's name on it.
Yes.
So in the NOLO software, it gives you the exact wording of how to open the name of the trust for a child's trust. Yeah. 50% off. Everything we need to be answering. For trust has nice binders or binders. So there's some back and forth on reading the questions and answers. Some people answering each other on the binders and stuff. Can you work on multiple clients at one time on NOLO, or can you import, export, save client trust files if possible?
Don't know.
Don't know, Jacob. I would have to. This was.
Good luck. Let us know.
Is it still exempt if house is not in a trust? Referring to medical. Oh, Medi-Cal is what he's saying. I wouldn't trust that. My understanding is there was a recent change in the law that if their house is in a trust, that avoids that look-back period and gives them a little bit better protections. So it's always better to be in a trust. It's always better to be in a trust because it's going to avoid probate. That alone should make people want to put it into a trust. But it's definitely going to help with Medi-Cal. But I'd love for someone to take that on and give us, that could be a whole nother mini class and teach us what those changes in the laws were. I swear it was like 10 years ago. It's been around for a while, and get everything updated on that. Elderly parent is a widow. There's no trust established for them. The grant is sandwiched between the widow parent and a young child. The grantor is sandwiched between them. So if the person has already passed and that's out there, I mean, it has to be transferred to the parent. And then somebody who's in charge of that elderly parent needs to do something with their
that may
with
be
all
an
that.
attorney question.
Yeah, because you're being very specific on their particular case, and I don't know what the options are. I don't know if they're capable, if they can sign a power of attorney. I mean, we just don't. That's a particular case. What specific forms do you file yourself on behalf of your client to make sure the real property gets transferred in the trust? File yourself on behalf of your client. I send it through the recorder. I have a cover letter that specifically even says that I'm fine. I'm asking for this recording on behalf of Mr. and Mrs. Smith. And so I have a cover letter. I send the grant deed in. I actually calendar for 2 weeks later to make sure my check clears. That's the first step to know that everything went through okay. And then I tell people, 30 to 45 days, they should get the original back in the mail. By then, if there's any problems, the recorder will have sent it back to you. And if that's the case, you call your client, say, hey, it got kicked back for some silly reason. Sometimes it's a code, sometimes it's anything. Sometimes they have to re-sign it and send it back in. So I just do a cover letter to the recorders. You don't have to have a cover letter. They know what to do when they get the document, but I always put one.
And every county is different.
Yeah.
So you might want to chat with the counties surrounding you, the recorder's office. Give them a call before you send it. Say, is there anything I need? Do you have any local rules that might pertain to this? So that you don't get it kicked back. Just depends. And every county has different filing fees.
Yes, that too.
So,
and some people have posted some info in the chat. The new Medi-Cal recovery laws, they were effective January 1st, 2017. So I knew it had been a little bit back, but yeah, so perfect. So let's look into that. So should a person transfer their property to their child now if they're on Medi-Cal and the house is paid off so they don't have to deal with medical? Look into the law because if you are just transferring it to avoid Medi-Cal, they can still go back and get it. So you want to look into the thing. The law has changed for the benefit of the people. So having it in the trust should be protecting it enough, but go to the new Medi-Cal law, Google that, the new Medi-Cal recovery laws. I just don't know them verbatim enough to want to give you guys information on that. I know it's better. I know it changed for the benefit of people where normally it's the other way around. Normally the state's getting the better end of the deal, but not in this case. So, so yeah, it's always better to have it in the trust. And then there's some cases where they're getting benefits now from Medi-Cal and stuff where you may want to get with an attorney or have them meet with an attorney because they may need a irrevocable trust or something along that line. So if you're really, really concerned, if they're very concerned with their Medi-Cal issues, they really should seek attorney advice first. And then if the attorney just says, no, 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 you can just do a revocable trust, then they can come back to you. Show us your email addresses. Yes, we can put our email addresses in the chat. Okay. So it looks like we've got pretty much all the questions answered. I'm going to go ahead and put my email in the chat. Is this to everyone? And then Nancy, I'll let you do the same.
I'll just give it to you.
Okay. All right.
NNEWLIN 2019 at Lusa, COLUSA.com.
All right, so there's mine and Nancy's email, so feel free. Give us some questions. We really appreciate everybody being here today. I know it's starting to get that time, so if you've got clients or just want to start your Saturday, go for it.
Great questions.
Yes, great questions, you guys. Thank you so much. You made it a lot easier to give the presentation knowing that, that we can answer such great questions and clarify things for you. So thank you very much. Appreciate all your guys' comments as well. We really appreciate that. If there's no certification of trust and the spouse has passed, what do you show the banks or whoever? Show them the whole trust then. Yeah. Show them the whole trust. There's no certification. And if everything passed to the spouse can sign and get a new certification of trust made up. So you can do that as well. But yeah, you can show the whole trust. It's just meant for privacy. So if you have the certificate, great. But if you have to show the whole trust, show it. Yeah.
All right.
All right.
Have a great weekend.
Thank you, everybody. We're going to stop recording.